Okay.
Now your phone's off.
All right, so, all right, well, let's jump in. All right, so everyone, if you all will please look up at the monitors, you will see that this is the Spalding County State Court. My name is Josh Thacker, I'm your judge, and this is the counter call for the bonded trials. All right, I want to start out by saying that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and dignity that you would wish for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. Our goal is to get you all back to your lives as quick as we can, and I will not have any patience with anyone causing disruptions or sidebar conversations or anything else. Nobody is virtually here. We did lose track of your virtual guy yesterday. Y'all let me know what you need for that.
We have his phone number, Judge, so
Okay.
we'll just try to call him.
Okay, that was on me. He got logged in as soon as everybody did this, and I forgot to tell y'all and the solicitor's office that he had logged back in. So, okay, cell phones. So everybody's human, I'm human, I have pet peeves. Pet peeves is cell phones ringing in the courtroom. So I'm just giving you fair warning that I respond irrationally to cell phones ringing in the courtroom. So here's what you do. You pull it out right now from whatever pocket and purse you put it in, and you turn it off. Then it won't ring, and then you don't step into my pet peeve. So let's do that right now. Save yourself that trouble. Otherwise, we will have a contempt hearing. And I don't think you should volunteer for that contempt hearing, because I understand if you push the power button for 2.5 seconds, it'll shut off. So my teenagers don't understand that, but I'm sure y'all get it. So, okay. This is the correct courtroom and this is really important because we have a lot of court going on today. If you were arrested here in Spalding for a misdemeanor here in Spalding County, you appeared or waived your arraignment date and requested a trial. And if what I'm saying sounds incorrect, step in the hallway and talk to the bailiffs. Ballard's on 3 and Coker's on 4 having criminals. So there's a lot going on today. Okay, there's always a response to that. That's okay. All right, today is your calendar call. I'm going to go over your rights with you, and I'm going to tell you what your options are, and then you or your attorney is going to tell me what to do with your cases. Now, each of you may have a trial. There are 2 types of trials. There's a jury trial where 6 jurors sit in that box over there and make the decision on your case. And then there's a bench trial where I make the decision with no jury present. You may have a conference with the solicitor's office if you're representing yourself. If you have an attorney here, they'll very likely do that on your behalf. You can ask me about having an attorney, and we will have a very awkward conversation about what you did or didn't do at your arraignment date when I asked you to apply with the public defender's office. But we can certainly have that conversation. All right. We're very blessed today. We actually have Ms. Leslie Heffron, the leader of our accountability court, so Veterans and Mental Health Court. So if you are a member of our military, or you are a military veteran, or you have a mental health diagnosis, and you would like your case dismissed, then if you're representing yourself, you can speak with Ms. Leslie at the first break. If you miss a chance to talk to her, you can ask for a conference, and we can explain and see if you are a candidate for our Veterans and Mental Health Court. If you're represented by an attorney, speak with your attorney. They're very familiar with our program, and they can help answer your questions to see if you are a candidate for our program. Okay, everybody here, your charges are misdemeanors. The average misdemeanor carries a maximum punishment of 12 months to serve in the Spalding County Jail and or $1,000 fine. A few minor traffic charges like seatbelt have a lower maximum fine, and a few high and aggravated misdemeanors have up to a $5,000 maximum fine. Now, each of you here have the right to a speedy and public jury trial, where 6 citizens of Spalding County decide guilt or innocence on your charges. Again, you can also choose a bench trial. Remember, that's where I make the guilt or innocence decision with no jury present. You can waive your right to a trial and close your case with a plea if you so choose. Now, I have no preference. You must knowingly, voluntarily, and intelligently choose for yourself. Now, everyone here has the right to be presumed innocent. You have the right to force the state to prove your guilt beyond a reasonable doubt. You have the right to cross-examine the state's witnesses, to subpoena your own witnesses and evidence to court. You have the right to testify or not testify, and not to incriminate yourself. If you choose to remain silent, your silence cannot be held against you. You still have the right to have an attorney. You may hire your own attorney, and there's plenty of private attorneys here you can talk to. Now, if you cannot afford an attorney, then you should have applied with your arraignment with the public defender's office on your arraignment date or very quickly afterwards. I warned you on that day that if you did not take action ASAP, you would very likely hear me say that you have waived the right to apply. All right, an attorney would help you understand our criminal justice system, explain what the charges are and what the defenses are to those charges, file motions on your behalf, engage in plea negotiations, subpoena witnesses and evidence for your defense, conduct a trial on your behalf, make objections, protect your record, appeal conviction, and otherwise work to protect you. All right, it is my job to explain first offender and conditional discharge. These each allow you to enter a guilty plea without being convicted. However, you only get one of each for your entire life. First offender is for everything except traffic-related charges, so no DUIs. And then conditional discharge is for drug-related charges only. Now, for those of you with traffic charges, you need to know that a nolo contendere is, we call this a nolo plea for short, is where you enter a guilty plea without admitting guilt, and it is available on most traffic charges, no DUIs. You get one nolo every 5 years, and that is measured from the instant date to the instant date, ticket date to ticket date. A nolo will usually prevent points. It will usually save your license. It will not help you much if you're under 21. All right, if you're here today and you're not a U.S. citizen, it's my responsibility to make certain that you understand that any conviction will very likely have a negative impact on your immigration status. All right, family violence charges. Several of you on this calendar are charged with family violence charges. It's in the title of your charge. If you are convicted of that family violence charge, then you need to know that you will lose your Georgia weapons carry permit. And federal law will step in and say that you may never again possess a firearm or ammunition. All right, habeas corpus. Weird old law that I'm responsible for telling you all about. And here's my best explanation of it. It does a lot of things in a lot of different situations, but for our purposes here today, here's how it works for you. If you're convicted of these charges, you may sue Spalding County civilly over in Superior Court to challenge your conviction. What I really need you to understand is your window where it expires. So all the traffic charges have a 6-month window to use your habeas rights before they expire. Everything else in this courtroom has a 12-month window to use your habeas rights before they expire. All right, you make conference today with the solicitor's office. If you're representing yourself and that's what you want to do when you hear your name called, you'll stand up and announce conference. If you have an attorney, your attorney will very likely announce that on your behalf. The solicitor's office, again, that's this group up here to your left. They all represent the state of Georgia. They're not your attorney. If you reach an agreement with the solicitor's office, you can resolve your case today. If you do not reach an agreement, you must return to this courtroom for me to personally give you your next set of instructions. Now, attorneys, what that is I have those folks sign a verdict form. So if you sign the verdict form with the solicitor's office, you and your clients do not have to return to the courtroom. I just need a verdict form signed before you leave. All right. If you receive probation today, you need to know that you'll be supervised by the Spalding County Sentence Enforcement. There's a one-time $25 intake fee. And 100% of all fines may be worked off with community service work at a rate of $10 per hour. Now, there is a $50 per month supervision fee each month until you complete your probation. It is mandatory, but it can be waived after a separate hearing before me. All right, this is a 2-week trial calendar. This is week 1, and you all are here for calendar call. We had a group come in yesterday. We have y'all today, and we have a third group coming in tomorrow morning. Then all of us are going to skip a week in the middle to prepare for trial. And then in week 2, which will start on the 28th at 9 a.m., you all will be here and you will stay each day until your case is resolved. We will use 2 courtrooms in the 28th, and we will reach your case for trial. All right. You want to help your friends and family. We're a small enough community where everybody knows somebody who knows somebody. So here's the deal. If you recognize the name of somebody who's absent and I'm issuing a warrant for, call them on a break, tell them to get down here, and you will definitely save them a great deal of future trouble. All right, attorneys and intrepid self-represented defendants. You must let me know if there are any outstanding pretrial motions, speedy trial demands, or anything I need to factor in to the scheduling of your case other than picking a jury. So if you do not get this information to me, I'm going to assume you're waiving it. Bench trials are automatically waivers of all pretrial motions. All pretrial matters must be heard on the first calendar or they are waived unless I specifically preserve those motions in open court. All right, I've titled this slide all kinds of titles, and I just went back to this is important because, hey, this is important. If you announced this morning that you want a jury trial or a bench trial, what you're telling me is you don't want a conference, you don't want an attorney, you do not want a continuance, you do not want a negotiated plea, and you don't have any motions. And because this is your last chance to explore those options, that's the whole point of calendar call, because I have zero intentions of exploring any of those on that list when I got a jury standing outside that door ready to start your case. All right, I'm about to call the calendar. When you hear your name called, stand up. If you're represented, if you're able. If you're not, just wave your head high. If you have an attorney, then let your attorney announce for you. That's an issue I don't know how to fix. I have a lot of people calling out what they want while the attorneys call out what they want. So if you have an attorney here, let your attorney announce for you. In other words, you just got one job, stand up. How about that? If you do not have an attorney, then you're going to announce for yourself what you want to do. So you'll say jury trial, or bench trial, or conference, or attorney. And again, that's for the self-represented folks. And then, of course, are there any motions? Okay. Let's jump in. Oh, who's in jail?
Page 3 and 4.
Oh, yes.
Gary.
We got that, Judge.
So y'all let me know if you on that.
And then page 6. Patrick Lamar Weeks at the top.
That's y'all's.
No,
Weeks is in
yeah,
jail?
Leaks is not in jail.
Okay.
Unless it happened really recently.
Is Leaks out here?
Yeah.
Okay, he's waiting on us.
Hold on a second.
Yeah, he's gonna be going into accountability court.
Well, this wouldn't be the first time we had name issues this week.
Yeah, I'll do this a second. There's some.
Junior or senior? Are you a junior or a senior?
Senior.
Senior?
Okay, it's Junior that's in jail.
Is your son incarcerated? Okay, that's all right. We've already had that happen once this week. So.
Yeah, they don't ever put Junior or Senior on there, so it
Well-
confuses me.
So that means that y'all represent junior. Y'all represent senior,
Yes.
and junior has something else somewhere else. Okay, I'm gonna add senior to my calendar.
And that's it.
Brandon, do you put senior on that plea sheet?
Yes, sir.
Yeah, because we had a very long hearing yesterday where we had 3 generations that were given fits. So this is the second time this has happened this week. Okay, that's it for everybody.
That's it.
All right, we'll see Mr. Holmes tomorrow after lunch. All right, so here we go. We'll start with Mr. Malloy. Nicholas Britton.
Conference, Your Honor.
All right, thank you, Mr. Britton. All right, back to you, Mr. Malloy. Joshua Brown. Joshua Brown. Now, there's no one virtual, I should say that out loud. There's no response from the gallery.
Well, that's for bond forfeiture and bench.
Okay, Buckley is not my case, it's not Mr. Shepard's case. I think it's Mr. Harding's case, and Judge Thompson's moved it, so Buckley is off this calendar. It's my understanding.
Not ours. And Ms. Bettis's office is handling that
Okay, I was wondering that, so.
from my office because we're recused on it also. I just told them we'd all announced this morning that there was nothing that has been continued by consent of all parties.
Okay, is anybody here on that case, Buckley? Witnesses, anybody? Okay, well, then we're good. All right, Ronald Combs, conference, thank you. All right, Elijah Cooper,
So Judge, Mr. Cooper's got a second case, it's 22 SR 0776. Mr. Cooper is currently in prison, and we anticipate that being a plea and abstention.
okay,
I've discussed it with Ms. Nichols, she's, obviously that's why he's not here today, but we'll have it resolved.
okay. So great. All right, back to you, Mr. Malloy. Kaylin Davis,
Okay, thanks.
all right. Reginald Dewberry,
Conference, Your Honor.
excellent. All right, either Mr. Hudson or Mr. Larkin, Justin Duncan,
Your Honor, that should be a plea.
all right.
And that paperwork's returned on that.
Okay. I'll stay on the bench if y'all have some ready and go ahead and take them before I take a break, if that'll work. Carmona Espinoza? Espinoza?
That's for bond forfeiture and bench warrant.
Naomi Flores? Flores?
Yeah, I think they think that's on this afternoon's interpreter calendar.
Well, I was just wondering. Yeah, there it is. Okay. So Flores is on for this afternoon, so I'm just gonna mark interpreter and we'll deal with this.
Is Espinoza?
It's paid.
Espinoza's paid?
That's what I was wondering. Okay, so not a warrant, paid and closed on Espinoza. Flores is this afternoon, and I see it on this afternoon's calendar. All right, page 3, Brian Grady. Grady,
That's for bond forfeiture and bench warrant.
and back to you, Mr. Malloy. Cynthia Gregg. Greg,
That's for bond forfeiture and bench warrant.
granted. All right, Mr. Hutchison, Austin Harper.
Your Honor, negotiated plea. Hey, Your Honor, is there any way that I can excuse myself outside and start going over?
That's a fantastic idea.
Okay.
So
Thank you, Judge.
you can come straight on across.
Judge, and I do have quite a few from other calendars.
Yes.
That's why
All right, if you're represented by Virgil Brown's office and I don't call your name, don't worry about it. They've got it under control.
Be the same with Mr. Singh. He's got folks with several calendars.
Perfect.
And Mr. Harper's got a second case listed on there. That is a duplicate.
Oh, it is. Okay. It happens. Okay, I marked it out. All right, Shanique Harris. Shanique Harris.
That's for bond forfeiture and bench warrant.
And, all right, Holmes is in jail, and I say y'all just let me know, Shanique. All right, David Jakes, Mr. Ford.
Yeah, remember court, he's in court in the county, he's on the way to.
Okay, you just sit tight. George, I'm just gonna put down for a conference. George Jarvis.
Conference, Your Honor.
Conference. All right, I got it, thank you. Stephen Jeffcoat. Jeffcoat,
So, Judge, this one's kind of odd. This was on the arraignment calendar, July 31st. And my understanding was it was reset to January then, but we just didn't catch that it was also on this calendar. Because in May, it was set for today.
The mayor was set for today, but it waived the arraignment from July, but he still showed up, but it made it on the calendar today, but then they reset it to January. It was so confusing.
Yes, I think he just signed a reset for January 2 weeks ago.
okay. I'm pulling it up. That's I'm right here. All right, well then I'm just gonna mark this as reset, and then we'll, unless anybody else needs to work on it.
No, I just don't think it would be quite right to ask for a bench warrant if he just got something saying be here in January.
Okay, that'll work. All right, Jeff gets off my list. Dameron Jones.
Good morning, Judge. Shelley St. Carter on behalf of Mr. Jones. This is going to be a negotiated plea this morning.
All right, that sounds
He is
great.
present.
All right, is this your only case?
Yes, Judge.
You're welcome to grab your client and grab the bailiffs and get a write sheet, and I'll go ahead and take the plea before I step off the bench.
Thank you.
I normally take them after, but since I got enough of y'all here, I think it'd be worth it to try this.
Yeah, it's written up. If Ms. Carter can get,
Yeah, the bailiffs.
did I send you a write sheet already?
You did, but it's cut off, so I may need another.
Yeah, the bailiffs have them over there.
Okay, thank you.
You can do one for both cases.
Yes, I will. Thank you.
Perfect. All right, back to you, Mr. Malloy. Barbie Kennedy.
It's strong.
So.
Conference, Your Honor.
Thank you. All right, and then Sherwin Kazal, that's Virgil Brown's office. That's the one with the.
It's on interpreter this afternoon, but that's going to be continued at defense request. It's the first trial calendar.
Okay.
You can confirm that, Mr. Hutchinson, that's what we discussed previously.
All right, let me just, let's talk about that off record a little bit, make certain to have the interpreter, because that requires a special interpreter. And I think I have them lined up this afternoon, but I'm not certain.
No, I didn't know we'd ever actually, I didn't think we'd actually done that.
I'm not certain, yeah, what I'm agreeing with you, saying I don't remember confirming with that interpreter, so I think we're okay. But I want to make certain I have them here when I'm supposed to. So, all right, Bernard Lannon, Ms. Brown.
So Ms. Brown is ill. She has COVID. She asked, it's going to be a plea. So we just told her to come in on the 28th. That morning we'll plead this case out for
Okay.
trials.
That sounds great. I appreciate you organizing that. May 28 it is. Okay, we've already established that Patrick Lamar Leaks Sr. is present and with Mr. Hutchison.
Yeah.
and that'll be a plea suspended on accountability court.
Okay,
He has not entered accountability court yet.
okay. Cornelius McDaniel,
Conference.
conference, thank you. All right, back to you, Mr. Malloy. Sherry McGee,
Conference.
all right.
I think
No,
that,
that one was no process, June the
No.
sixth.
yes, that's correct.
Oh, okay. Got it. Marking that off the list. All right, Cesar Maria, Murillo,
That's on the interpreter calendar this afternoon.
okay. All right, Ms. Myers is here.
Conflict.
Okay, y'all let me know, Shane, on that.
Yes.
All right, that's page 6. Page 7, Leon Owens. Owens, two cases.
For bond forfeiture and bench warrant on both.
All right, let me know when you find your client. All right, Miyoshi Ragland.
Conference, Your Honor.
All right, that's yours. All right. Perfect. All right, Mr. Singleton's Destiny Ritchie.
It's gonna be a conference.
They got it. That's okay. I'm looking to see if y'all are here and for the attorneys to announce. One day I'll figure out how to give those instructions correctly. All right, that's two cases. Back to you, Mr. Boyd. Sarah Smith. Sarah Smith.
That's for bond forfeiture and bench warrant.
Okay. All right, Mr. Smiley. Antoine Warner.
Yes, Judge, Mr. Warner's here. Judge, I believe we're gonna resolve that this morning, but I just need a brief conference with Mr. Shepherd to talk about some details.
All right, that sounds great. Thank you. Harris Waterman. Waterman. Good morning. Conference. Thank you.
And motion, Your Honor.
You okay? Well, go have your conference and then we'll address your motions. Barry Williams, Mr. Singleton.
Conference on that case.
All right, thank you. All right, Mr. Abbott, Zapata, Jordan.
Judge, I have a leave beginning the Tuesday of the trial week, and I have a felony case this Thursday in McDonough. We ask for a one-time continuance.
Okay. Has it been continued previously?
No, Your Honor.
Okay. Let me take a look at that. We'll just talk in just a moment.
Got his license.
Yeah. I want y'all to have a quick conference and then tell me. Yeah. Y'all do that first if you don't mind. That looks resolvable. Okay. All right. So if you're represented by Virgil Brown's office and I did not call your name, just raise your hand for me. Virgil Brown's office, y'all are in hand. You're on a different calendar and they've got your cases they're already working on. If you're represented by Mr. Singleton's office and I didn't call your name, raise your hand. Okay, y'all are in hand as well. Like I said, we went ahead and went over it yesterday. We just were trying to keep the attorneys from having to come in each of the three calendars because it just gets spread apart. Okay, so you're good. Now, are there any witnesses here who are subpoenaed by any of the parties to be here today? Okay, no. All right, so anyone else whose name was not called that I haven't previously addressed, stand up for me. Okay. Here, this is Hawkins, right?
Right, yes.
And we're gonna do that plea this morning?
That's correct.
Okay,
How did
that's,
that end up?
I don't know, but it's fine. Y'all have already, it's just a time served, isn't it, or something?
That be it, yeah.
Okay.
I'll just briefly conference with Mr. Shepherd.
Okay. I'll take that before I step off the bench then. Okay. Anybody else?
There are several of you who do not have an attorney who have asked for a conference. If that's you, what's going to happen is in a few minutes, either Sherry Middleton there with a white sweater on, or Miss Lenise Fletcher over there with a white sweater on, we'll begin calling names. We call up 4 or 5 at a time. When they call your name, follow them out the double doors over here to my right, your left. There's a hallway, there's a little waiting area outside my office. Just have a seat there, and I'll call you back one at a time for your conference. When you're done with your conference, you're going to come back down the same hallway through the same set of double doors. Quietly have a seat here in the courtroom, to either enter your plea or get instructions for your trial in a couple of weeks. When you come back to the courtroom, make sure you use the double doors, not that single door over there. If you do that, you'll disrupt court, make the judge unhappy. Not a good way to start the Tuesday. Obviously, there's a lot more of y'all than there are of me, but I know what I'm doing. I do this pretty much every day. I move quick. I'll have everybody out here in a decent hour. Lawyers, if y'all could just hang here in the courtroom, I'll start calling y'all back one at a time, run through your cases. If y'all flood my office, it just makes it almost impossible. So bear with me. I'll be with y'all in just a few minutes. All right, thank y'all.
Good morning. My name is Terrence Malloy, and to my left is Mr. Harry Charles. We both represent Duke Star for public defender here. As you heard when the judge was calling up your name came up and we represent you, we set conference for you. What that means is that we have already looked through your file with the prosecutor. We have notes. Put your name on the bottom of the pile. You wait till we come back to it again. If I come back to your name a second time and I put you on the bottom of the pile, then you have to speak to the judge. Again. This is repetitive for us, but for you, you're hearing this for the first time. Lo and behold, every single court date we have, someone disappears on us. Happened yesterday, and I imagine somebody's gonna do it today. Hopefully none of you, but that's what happens. So all I'm saying is help us help you by being present when we call your name. Now the judge is gonna tell you, if you have to go to the restroom or something like that, that's fine. We're all human, we have that, you don't have those needs. But please be present when we call your name, and we come out here and you're not here. This slows down the process. You know, like Mr. Shepherd says, you do this all the time. We're really good at this. We're really good at this, so we will get you out here in a decent hour this morning. But help us help you by being present. Other than that, I don't think we got anything else. Okay. That's all I want to say. Just thank you very much. And again, be present when we call your name. Thank you.
And I just want to tell you, Mr. Malloy there is not beating a dead horse. I issued a warrant as recently as yesterday. So this is what happens. Here's the instructions I'm about to give you. You ready? They're super simple. Hey, we're all human. We all had coffee. Step to the restroom. Get back to your seats. Like, that's the instructions I'm about to give you. Step to the restroom. Get straight back to your seats. But every single day, somebody, I don't know, goes to get an oil change, a haircut, mow their yard real quick. I'm not sure what they do. And I don't know why they think that's when they should do it. But the fact that we've had to create a system for this is infuriating to me, considering my instructions are super clear. You got one job. Step to the restroom, get back to your seats. So I had to issue a warrant as recently as yesterday, and then we had to do another one before that. So statistically, one of you are going to volunteer to go to jail today. Don't be that person. Just do what I'm asking you to do, and that way we can move forward as quickly as we can. Again, I'm sorry to beat a dead horse. I'm sure y'all will be the first group where somebody doesn't wander off, but statistically, one of you is going to wander off. Okay, so that's it. I have pleas that are ready. Let's just take about 3 minutes for y'all to go get reset, Mr. Shepherd to get reset. I'm just going to sit here while everybody moves around, and then in about 3 to 5 minutes, and we'll start taking pleas. So, all right, that's it. Those of you who need to go to the restroom or whatnot, remember the instructions. Step to the restroom, back to your seats. That's the instructions. We're at ease for 5 minutes.
Nicholas Britt.
Mr. Huss.
Nicholas Britt.
You want to take yours first?
I'm going to just go and meet you.
Our system seems to work. So just do all just like don't actually sentence them. We do it because I don't sign this here. But I've got a couple pleas that are ready, and I'm gonna go ahead and knock these out and then take a break. All right, let's start with Patrick Leaks. This is an accountability court plea, and so Ms. Canfield will create a transcript. All right, Mr. Leaks, if you'll step up to the podium there and raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down and state your full name, including your title.
Patrick Ramali, Senior.
Senior, okay. And just for record purposes, your son is incarcerated. And we had some confusion, but you're senior. We're going to add that to the paperwork and add that to our system to make certain that's good and clear. Mr. Leaks, it's my understanding that you're wishing to enter a plea to go into our accountability court. Is that correct?
Yes, sir.
All right. So according to my memory and my calendar, you were on time for court this morning. Is that correct?
Yes, sir.
Did you hear the rights I read out to that court?
Yes.
Did you understand them?
Yes, sir.
Any questions I can answer to you about any of those rights? I'm holding up the written version of those rights, which is this attorney and defendant plea rights waiver that your attorney, Mr. Hutchison, has given me. Do you recognize this document I'm holding up?
Yes.
Are those your initials next to each of the lines on page 1,
Yes.
page 2,
Yes.
and is that your signature?
Yes.
Could you sign and initial this document after having all the time that you needed to review it
Yes.
and to ask your attorney any questions you have about it,
Yes.
and because you understood everything that's on it? Have you had all of the time that you need to speak with your attorneys about all aspects of your case?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
All right, do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes.
Do you have any questions for me about anything on this document or anything else before I pivot to your attorney with my next set of questions?
Yeah.
All right. Mr. Hutchison, do
Yes,
you stipulate as to count 1 with the DUI on 22 SR 446 from 4/17/21, there's a sufficient factual basis for me to accept this guilty plea?
I do, Your Honor.
And Mr. Leaks, do you wish to enter a guilty plea to count 1 DUI?
Yes.
All right, count 2, failure to maintain lane. Mr. Hutchison, from the same course of events, do you stipulate the factual basis?
We do, Your Honor.
And Mr. Leaks, do you wish to enter a guilty plea to failure to maintain lane, count 2?
Yes.
All right, I'm going to find with Mr. Hutchison's stipulations to the factual basis combined with Mr. Leaks' request to enter a guilty plea. There's enough for me to take pleas on count 1 and count 2. I'm going to find that you're knowingly, voluntarily, and intelligently waiving his rights. I reviewed the recommendation, and should I be required to sentence on this case, I will be following the recommendation exactly as it has been presented to me. Now, this is the moment where I would normally pivot to the attorney for pre-sentence information. I will say at this moment that this is an accountability court plea, which means I will not be sentencing at this moment, but I do need to put on the record that Mr. Leaks, are you waiving the right to withdraw this plea unless and until you successfully complete our accountability court program?
Yes.
All right, Mr. Hudson, do you agree with that? Is that the correct understanding of what's going to happen next?
Yes, Your Honor.
Okay. Mr. Hudson, is there anything you wish to put on the record before I adjourn this?
Your Honor, just so everyone in the accountability court program knows, including Your Honor, Patrick has been toying with the idea of going into accountability court. It kind of appeared at first blush that he was slow playing it and not actually being committed to doing it. But what it was a concern with his employer. His employer is now backing him 100%. And thanks to the Leslie, she was able to compose a letter that really got her, his employer behind the program and that kind of stuff. So anyway, I just want the court to know, I understand he's been on a couple of calendars and for the intent of getting into accountability court, but that was the delay.
Well, that's okay. And sometimes there is a delay and sometimes we have some obstacles we have to overcome. So
Yes,
we are okay there. And Mr. Leaks, I just want to welcome you to the accountability court program. I'm incredibly proud of what Judge Essery has created over there in that division. And of course, we're blessed today. We have, the person in charge of the whole thing over here and with Ms. Leslie Heffron, who has done a wonderful job putting this program together. They have an amazing tribe who support each other and who help each other. And I think you're going to find that the crowd that you're about to move into is a wonderful group of human beings that care for each other and support each other. And you're gonna find a new family there, for lack of a better word. So, all right, anything else y'all need?
No, Your Honor.
All right, then what I'm gonna do is I'm going to say that he's already signed it, you've already signed it. The original here, I'm gonna go ahead and pull it off. This is gonna be attached to the contract and it will be filed with the clerk of court. The yellow copy, the pink copy are y'all's to keep. And that way, if there's ever a question, and I'm passing those down now, if there's ever a question, Mr. Leaks will know. If I ever do have to sentence him, it should not happen, but if I do, Mr. Leaks and you will know exactly what to do, or exactly what I'm going to do. Mr. Leaks, it's my sincerest hope that you and I never have to cross that bridge. I look forward to this being withdrawn and seeing a dismissal with your name on it, or a null process more formally. But it's my job to say awkward things out loud, and just say it out loud, is that if you are removed from the program, then, and I am required to sentence you, I will follow it exactly according to the terms that have been negotiated and that are on that sheet. So,
Yes, sir.
other than that, welcome to the accountability court. You're gonna love it. It's a wonderful group. Anything else, Mr. Leaks? Anything else, Mr. Hudson?
No, Your Honor.
All right, then I'm gonna pass this down, so you, the clerk, and we'll attach the contract.
Yes, sir.
Mr. Leaks, just make sure you check in with Ms. Heffern on the way out and do what she tells you to do next. So, all right, I think y'all have somebody else.
Yes, Your Honor. I think Emmett Jefferson is up
I
there.
have that here.
Okay.
Jefferson?
He needs to talk to Leslie.
Just checking.
All right.
I always have whoever pleads the account book or check in with Karen, so since Leslie's here.
We'll make it work. Yes, sir.
All right. You are Emmett Jefferson?
Yes.
All right, Mr. Jefferson, confidently grab that hood mic, pull it up, and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, take your hand down, state your full name for me.
Emmett W. Jefferson III.
All right, and Mr. Jefferson, you are here on 22 SR 0687, and according to my calendar, you were on time for court, is that correct?
Yes.
All right, did you hear everything that I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes.
Are these your initials next to each of the lines on page 1?
Yes.
And then page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it
Yes.
and to ask your attorneys any questions that you have about it?
Yes.
Because you understood everything that's on it.
Yes.
Are there any questions I can answer for you about anything on this document?
No.
Mr. Jefferson, have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes.
Okay. Do you have any questions for me, no matter how large or small, about anything so far?
No.
All right, you ready for me to pivot to your attorney and talk about the facts of your case?
Yes.
All right. Mr. Hutchinson, do you stipulate that there's a sufficient factual basis for me to accept in 22 SR 687 from January 22nd, 2021, this count 1 reckless driving plea?
Yes, Your Honor.
Do you wish to enter a guilty plea to the reckless driving plea? Your reckless driving charge, excuse me.
Yes.
All right. And then, Mr. Hutchinson, back to you. Do you stipulate to the failure to maintain lane factual basis?
Yes, Your Honor.
And Mr. Jefferson, do you want to enter a guilty plea to count 2, failure to maintain lane? All right. Then I'm going to find that between Mr. Hutchinson's stipulation and Mr. Jefferson's request to enter guilty pleas, that there's enough for me to accept the pleas on both of these counts. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering a plea. I've reviewed the recommendation and I will follow it. Mr. Hutchinson, the floor is yours if you wish to put anything on the record.
Your Honor, just briefly, I passed up to the court 2 forms. One's a drug and alcohol evaluation, and the other is proof of some community service that was done after this incident in 2022. My client is a sole business owner and his sole employee. He was extremely proactive in getting these things done. When we realized that we were going to enter into this plea, we would just ask for credit for completion of those 2 terms of his sentence, and ask if the court would give him a little bit more of latitude in light of the fact that he's done those things. As far as reporting, maybe make it telephone reporting or virtual reporting of some sort. He's really concerned about whether he can survive and, shut down his business to go report, come back, whenever. And that's his concern. I told him that the court would look kindly upon the fact that he was proactive.
Oh, yes.
But that it was ultimately up to the court. Patrick did not object to giving him credit for those two things as far as the terms of this probation.
All right, now as far as, to take those in reverse order, I have the clinical evaluation form from Shannon Eller. She is on the approved provider list, so I don't see any reason off the top of my head as to why the clinical evaluation should be an issue. As to take the trade, what I don't know off the top of my head, because we have such a substantial list of approved providers, I don't know if they're on the list or not. And so if they're on the list, then that's an easy yes. If they're not on the list, then there'll be two things they'll need to do. They'll need to see who these people are and make certain that they comply with our requirements. I see they're local, so if they're not on here and they're doing a good job, we should have them.
Yes,
And so that's all I'm telling you is that I don't know. I just can't remember off the top of my head if they're on the list or not.
Yes,
So if they're on the list, you will get credit. If they're not on the list, then there's two steps, the evaluation and then a determination.
yes,
So only one of those three ends up with you getting no credit. So I would say it's probably a good start. So,
yes.
and the short answer as far as reporting goes, we strive hard not to interfere with employment. And so I can tell you right now that you don't need an official direction from me. You go show this to probation. Director Matthews is absolutely going to take this into consideration and is going to work with you because she's a director of our sentence enforcement department for a reason. Because she understands our goals. Our goals are to help you come back out of this better than you started.
Yes.
Okay, that's all reasonable, and we'll go from that. If you'll pass that back to Mr. Hutchison. Okay, anything else?
No, Your Honor.
Mr. Jefferson, any questions about my responses? Good job on that, by the way. I'm a huge fan of folks doing remedial measures, and I'm very confident that's going to work out for you. I just need them to do a little bit of homework before we officially say yes. It's official yes on the clinical, on the other one.
Yes.
All right, Emmett Jefferson on 22 SR 687 from January 22nd, 2021, count one, reckless driving. I'm gonna find you guilty. It's 12 months probation, a fine of $1,232. Count two, failure to maintain lane, guilty, 12 months, consecutive, $156.50 is your fine. You may work off your fines with community service work at a rate of $10 per hour. There'll be 24 total months of probation, and get your valid license back or show a valid license to probation if you still have it. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 one-time intake fee per case, 40 hours of community service work. I didn't catch how many hours that was. I just assumed it was.
Your Honor, it actually says that he was supposed to, according to the sentence, it was going to be 40, but he exceeded that.
Right.
So, but they didn't give an exact number.
Okay, so that'd be fine if it was greater than 40. And then substance abuse evaluation, show that you're good. The moment 12 months have passed, no violations have occurred, and all of your conditions have been met, then your case will close. Again, as far as the reporting goes, probation's goal is not to interfere with your employment. And so you do what you're supposed to do, and I think you'll be very pleased with the response you get from the Sentence Enforcement Office. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you want to use your habeas rights. Do you remember me talking about habeas earlier?
Yes.
You remember reading about it on the back of the rights?
Yes.
Do you need anything else from me, Mr. Jefferson, before you and I part ways?
No.
All right, if you will walk out with Ms. Yarborough out those double doors, meet with probation, and good luck to you. What else do y'all have? That's it for y'all.
That's it. I think Larkin was signing up some folks while I was doing it. But
All right, Jones?
Can I put some in?
Do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And you, according to my calendar, were on time for court this morning. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions that I can answer for you about those rights?
No, sir.
You, your attorney, Ms. Carter, has passed up to me this attorney and defendant plea rights waiver, which has both of your case numbers on them, 22 SR 610 and 22 SR 922. Do you recognize this document that I'm holding up?
Yes, sir.
Do you recognize it as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions that you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Any questions I can answer for you about anything on this document?
No, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your cases?
Yes, sir.
Are you satisfied with the job she's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial on your cases?
Yes, sir.
And that by entering this plea, there will be no trials and this case will be closed? Is that what you want to do?
Yes, sir.
Okay. Mr. Jones, do you have any other questions for me about anything we've covered or anything you thought of before I pivot to your attorney with my next set of questions?
No, sir.
All right, so, Ms. Carter, starting with 22 SR 922, are these two cases concurrent?
They are concurrent.
Okay. So I'm just gonna start with the top one then. On 22 SR 922, from January 1st of 2021, do you stipulate that there's a sufficient factual basis for me to accept this obstruction plea?
Yes, sir.
Yes, Judge, there is a sufficient factual basis. He would also like to enter that plea under the First Offender Act, and the state is not opposed.
All right. Has he used first offender on any other charges
He
anywhere
has not.
else? All right. Then you qualify for it. And Mr. Jones, do you understand that if you use first offender on this charge, you will not be able to use first offender again in any other court ever for any other charge?
Yes, sir.
And that what I get a lot of is folks who catch a misdemeanor, they use their first offender now, and then, I don't know, 10 years from now, they catch a felony, they can't use it, and then they want me to fix it. And the answer is no.
In the event that something happens in the future, however, he said that he wanted to use it. Judge, are you still certain that you want to move forward with that under first offender?
No, sir.
Okay.
Okay.
And I don't have a preference, it's just that, you know, I just want to make certain you knew the risks and rewards of it fully.
Thank you, Judge.
All right, do you want me, so I've already initialed it and said yes. Would you like me to mark it out, Mr. Jones, and remove it?
Remove it, yes.
Okay. All right, well, I'm gonna remove it then and initial it, saying that we talked it through and that after asking questions and speaking with your attorney and on the record, you've elected not to use your first offender here. Okay, so Mr. Jones, your attorney has stipulated the factual basis of the obstruction charge. Do you wish to enter a guilty plea to that charge?
Yes, sir.
All right, I'm going to pivot over to 22 SR 610. That's your second case. Attorney Carter, do you stipulate on count 1, the reckless driving plea, that there's a sufficient factual basis?
I do, Judge.
Mr. Jones, do you want to enter a guilty plea to that reckless driving charge, which is count 1?
Yes, sir.
All right, back to you, Ms. Carter. Ms. Carter, on count 3, do you stipulate to the factual basis on the disorderly conduct?
I do, Judge.
And Mr. Jones, you want to enter a guilty plea to that disorderly conduct charge?
Yes, sir.
Okay. All right, so I am going to find across both cases that between the attorney's stipulations to the factual basis combined with Mr. Jones's request to enter the plea, there's enough for me to take the plea. I'm going to find that Mr. Jones is knowingly, voluntarily, and intelligently waiving his rights in entering the plea. I reviewed the recommendation and I will follow it across both cases. If you wish to add anything, the floor is yours.
Judge, Mr. Jones, we've had this case for a while. He's always wanted to come before the court and take responsibility for his actions. He's remorseful for what happened and he's ready to move forward. He's a very hardworking gentleman. And so I don't believe that we'll see him again in this instance. And we've asked you to accept the plea as negotiated.
All right, and you've done a good job negotiating these. These are good deals for your clients. I am going to follow the recommendation and I am going to sentence according to the terms that have been agreed to.
Thank you, Judge.
Mr. Jones, do you have any questions for me about anything before I sentence?
No, sir.
You ready?
Yes, sir.
All right, here we go. Aaron Jones, I'm going to start with 22 SR 0922. from January 1st of 2021. Count 1, obstruction, I will find you guilty. It's 12 months probation, $590 is your fine. Counts 2 and 3 on this case will be dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. You would tested for those. Fourth Amendment waiver, $20. So it'd be a $25 case, intake fee per case. So just make sure that that's clear. The reason I'm saying that is because the $50 supervision fee is across both cases. So $25 intake fee per case, $50 supervision fee across both cases. Because they're concurrent.
Yes, sir.
All right, that concludes the sentence on 22 SR 922. All right, moving on to 22 SR 610. Count 1, reckless driving, guilty, 12 months, 1232 is your fine. Count 3, disorderly conduct, guilty, 12 months consecutive, $300 is your fine. That's 24 total months of probation. Count 2 is dismissed. The same responsibilities apply. So license, searching, no alcohol, illegal drugs, or hemp products. You will additionally complete 40 hours of community service work. A substance abuse evaluation shall be completed within 90 days. And once 12 months have passed, no violations have occurred, and all conditions have been met, then your case will terminate. So if you do everything you're supposed to do, your case will close after 12 months. You have 30 days from today if you wish to appeal this decision. You have 6 months from today on the driving offenses, and you have 12 months from today on the not driving offenses to use your habeas rights before they expire. You understand that?
Yes, sir.
And do you have any questions for me about anything before you and I part ways?
No, sir.
All right. Ms. Carter, anything else before we part ways?
No, Judge, thank you.
It's a pleasure having you down here.
Thank
So,
you, Judge.
and you come back anytime. We'd love to have you back.
Thank you.
Thank
Have
you.
a good day.
All right. Let's see. All right. Next case I have is. That one is? Okay. All right, I'll come back to that just a minute. Any attorneys with one case that needs to do you have to, you still waiting for your conference?
No, Judge, we got the paperwork turned in, Antoine Warner.
Got it, okay. I'm gonna take that and get you on that in a minute, so. Warner? All right. If you will, please step up to the microphone and raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Please state your full name for me.
Antoine Marcus Warner.
All right. And Mr. Warner.
Senior.
Senior?
Yeah.
Thank you for that. Okay, so according to my calendar and my memory, you were on time for court. Is that correct?
Yes.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No.
Mr. Warner, your attorney has passed up to me this attorney and defendant plea rights waiver, which is the written version of those rights. I'm holding this document up. Do you recognize this document?
Yes.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time you needed to review it? And speaking and asking your attorney any questions you have about it?
Yes.
And are there any questions I can answer for you about anything on this document?
No.
Mr. Warner, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes.
Are you satisfied with the job Mr. Smiley's done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial, and this case will be closed? Is that what you want to do? All right. Do you have any questions for me about anything we've covered so far or anything you thought of before I pivot to your attorney with my next set of questions?
No.
All right, so, Mr. Warner, you, well, I may have, we can finish the plea, but I think I misplaced your information sheet. Did you fill out a probation information sheet? If you didn't, that's fine, we can do it afterwards.
I didn't receive one of those.
That's okay, we can do it afterwards, so, all right, so just, the bailiffs will get with you afterwards, that's fine, I just wanted to make certain I had all my boxes checked. Okay, back to the plea. Mr. Smiley, do you stipulate as to, on 22 SR 0624 from January 29th of 2022, that there's a sufficient factual basis for me to accept this terroristic threats plea?
Yes, Your Honor.
Mr. Warner, do you wish to enter a guilty plea to this terroristic threats charge?
Yes.
Okay. All right, then I'm going to find with Mr. Smiley's stipulations, the factual basis, combined with Mr. Warner's request to enter a guilty plea, and there's enough for me to take the plea. I'm going to find that it's knowingly, voluntarily, and intelligently waived his rights. Am I correct that this is a first offender plea?
That's correct, Judge.
Okay. Has he used first offender previously?
No, Your Honor.
All right, and otherwise, to your knowledge, he qualifies?
That's my understanding, Judge.
Okay. And Mr. Warner, the way first offender works, just to make certain you understand it clearly, is that by using first offender today, you will never be able to use it again in any case, in any court, ever. Do you understand that?
Yes.
Is that acceptable to you?
Yeah.
Do you understand that you must complete all conditions of probation? Or if you don't get a trial, we have a hearing where you stand there and I'm here, and I could take away that first offender protection. Do you understand that? Yes?
Yes.
Okay. And that if I take it away, you both used it, lost it, and you're convicted of the charges. Do you understand that?
Yes.
All right, so I want you highly motivated to do your best. I'm sure you would be anyway, but it's my job to say awkward things like that out loud. Okay? All right, so then I'm going to find that the negotiation's proper, everything is approved. Follow the recommendation. Mr. Smiley, the floor is yours if you wish to have
Yes, Judge, Mr. Shepard has agreed that Mr. Warner can do an anger management assessment and then follow any recommendation. And also, because Mr. Warner is a truck driver and is very often on the road out of state, Mr. Shepard had no objection to Mr. Warner reporting to probation by phone.
Okay, and we've just upgraded our system to a new system, and it's actually more flexible. And so it's not just phone report anymore. It's now, we're calling it electronic report. So it gives your client more options of how to check in other than picking up the phone and making a phone call. So you'll be pleased to hear that although the form says phone report because that's what it was when we printed the form, it's actually much better than that now. So.
Okay, Your Honor.
Okay, and that's a yes for me. Anything else?
That's it, Judge.
All right. Mr. Warner, you ready for me to sentence? All right, here we go. Mr. Warner, so Antoine Warner Sr., 22 SR 0624 from January 29th of 2022. Count 1, terroristic threats. I'm going to find you guilty. Is 12 months probation. $735 is your fine. Now, I'm going to finish the sentence, but the entire sentence will be withheld under the first offender protections, which means that it won't go in your criminal history as a conviction. And it will never go on there unless and until I, in court, have a hearing and revoke your first offender. Now, subject to completing it, it will say that it's completed without a finding of guilt, and it'll be cleaned up. So that's the first offender protections. While you're on probation, show your valid license to probation. No illegal drugs, hemp products, or alcohol. You'll be tested for those. $50 per month supervision fee. A $25 intake fee will be paid to probation. Anger management evaluation within 90 days. Anything that's recommended will become a part of the probation. I assume you just explain that to your client.
Yes, Judge.
Okay. No contact whatsoever with Brittany Mays, and then you're on electronic report after your orientation. So you will have to report one time to probation. As long as you do what you're supposed to do, you will remain on e-report. So you have 30 days from today. If you wish to appeal this decision, you have 12 months from today if you wish to use your habeas rights. Again, I missed the fact that we didn't have a probation sheet, so if you'll get with the bailiffs, Ms. Yarbrough's got it in her hand. She's gonna have you go ahead and fill that out and then walk you out to go to probation. Mr. Smiley, anything else before I adjourn this here?
No, Your Honor.
Thank you, Mr. Warner.
Thank you. Thank you, Judge.
Judge, I just need to report that I'm here.
Hey, welcome.
And if it's all right with you, I'm gonna go talk to them and come back. Thank you.
Yeah, he's gonna send you right back, just so you're aware, he's gonna send you right back to here, but I don't wanna know you're there. He's asked everybody not to mob him back in his office, but he doesn't know you're here, so go let him know you're here,
I'll go play like I didn't know that.
and then come back. You ready?
We're ready.
All right. All right, this is an add-on to today. Hawkins. Again, the numbers are 21 TK 4506, 22 SR 0173, and 22 SR 0684. And these are all going to be time served, so there's no probation acknowledgement sheet, there's no probation. And he's already served all this stuff.
That's correct.
Okay. Yeah, I'm trying to send it back unless y'all have it. So, well, I'm trying. I'm slowly getting them redirected. So, all right. Harper, this one's Hawkins is ready. All right, Mr. Hawkins, raise your right hand for me. Do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Mr. Richards is going to bring you back. There's just a couple of lines on there that you missed in your initialing. Easy fix. Take a moment and do that.
Excuse me.
Yeah, folks, I wanted to know if we would like to take this under Alfred versus North Carolina.
Yeah, that's fine. Okay. All right, I'll mark that on all three. Okay. All right, so, Mr. Hawkins, according to my memory, you were on time for court this morning, is that correct?
Sure.
All right, did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Hawkins, I have this attorney and defendant plea rights waiver, which has all three of your case numbers on it that I'm holding up. Do you recognize this document as the written version of those rights I read out earlier?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2,
Yes, sir.
and is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Okay, I'm just gonna initial that line for you, saying we did that here. Okay, do you, have you had all the time that you need to speak with your attorney about all aspects of all of your cases?
Yes, sir.
Are you satisfied with the job Mr. Howard's done on your behalf?
Yes, sir.
You understand you have the right to a jury trial,
Yes, sir.
and that by entering this plea, you'll have no trial on any of your cases, and all of your cases will be closed.
Yes, sir.
Is that what you want to do?
Yes.
All right, Mr. Hawkins, do you have any questions for me about anything else before I pivot to your attorney with my next set of questions?
Yes, sir.
All right. Mr. Howard, we'll just start with 21 TK 4506. Do you stipulate under the Alford standard that there's a sufficient factual basis for me to accept this best interest plea on speeding 89 and 55?
Yes, I do, yeah.
All right, Mr. Hawkins, you want to enter a best interest guilty plea to that speeding 89 and 55?
Yes, sir.
All right. Moving on to 22 SR 173 from March 10th, 2020. Mr. Howard, do you stipulate there's a sufficient factual basis under Alford versus North Carolina for me to accept this concealed weapons charge plea?
Yes, I do, yeah.
And Mr. Hawkins, do you want to enter what we call best interest plea for your purposes? It's offered. Do you want to enter a best interest plea to this concealed weapons charge?
Yes, sir.
All right. Last case, 22 SR 0684 from February 22nd of 2022. Mr. Howard, do you stipulate as to the best interest offered standard that there's enough for me to accept this obstruction plea?
Yes, I do, yeah.
All right, and Mr. Hawkins, do you wish to enter a best interest plea to this obstruction charge?
Yes, sir.
All right, I'm gonna find, that between the stipulations of counsel, with the offered standard, as well as Mr. Hawkins' request to enter best interest pleas on each of these charges, across all three of these cases, that there's enough for me to take these pleas. I'm gonna find that he's knowingly, voluntarily, and intelligently waiving his rights to entering those pleas. I reviewed the recommendations, and I'm gonna follow them exactly the way they've been negotiated. There's simply time served, and he served the time, so there's no probation conditions. So, anything else you wish to add, Mr. Howard?
Your Honor, we asked the state for one other consideration. As the court might remember, he has a felony charge that's pending. And in discussing whether or not he should exercise his first offender rights, I advised him not to do that at this time. But what I did ask the state is whether or not they would have any objection to, after 1 year, if he was not involved in any criminal activity, that we could make an application to the court to get his record expunged after the year. What the solicitor, what Mr. Shepard says, is that after the felony cases are disposed of, he said that he would entertain that suggestion after that trial was suggested, and I wanted to just put that on the record.
Okay, and the short answer is that I'm not quite sure off the top of my head what the procedure is. We just did that with someone else, but they got convicted of it, so that was a slightly different situation. So the short answer is that I'll just simply say, for my purpose on the record, is that if what you're describing comes to pass, and if it's allowed by law, I would certainly consider it. And so that's the best I can give you right now. So let's take a quick time out, because if I slow them down, everything stops. Okay. Floor's yours.
Can I please see the following people through these double doors? Ronald Combs, Cornelius McDaniel, Harris Waterman, Brian Grady, Shanique Harris, and Courtney Wilkins.
This goes back to this time. Brendan Hawkins.
All right, name's been called, everybody's out. Let's come back on the record with Mr. Hawkins. All right, anything else before I send it?
John, we have nothing else.
Mr. Hawkins, do you have any questions for me about anything? Mr. Hawkins, I just want to acknowledge that it's well known in this court that folks that come in here with a coat and tie, or at least a tie and a dress shirt, it does make an impression. And I just wanted to let you know that it's not lost on me. I normally introduce you fine, but you don't have a fine. But I just want you to know that the court is very grateful for you to take time, basically dress for church today. So, okay. With that, the sentence of the court then is as follows. Here we go. Brandon Hawkins on 21 TK 4506 from 11/24/21. These are all best interest pleas. Count 1, speeding 89 to 55. Guilty, 12 months to serve. He has served that. I'm initialing the line that says credit for time served in full. And this case is closed. There's no probation conditions on any of his cases. And that's it on that case. All right, 22 SR 0173 from March 10th of 2020. Also best interest plea. Concealed weapon, guilty, 12 months to serve. Count 2 got dismissed, is going to be dismissed. Credit for time served in full. No probation conditions. Last case, 22 from 22 SR 0684. Best interest plea, obstruction, guilty, 12 months to serve. Time served in full. All of these run concurrently, equaling 12 total months to serve. Okay, that concludes the case. You have 30 days from today. If you wish to appeal any of these decisions, you have 12 months on each of your cases if you wish to use. You should already sign it. So, Mr. Howard, if you'll sign on the attorney line there on each of those, Mr. Hawkins, if you'll sign on the defendant line, as soon as y'all sign that, the bailiff will take them apart and give you all copies, and you're free to go. Anything else, Mr. Howard, before I adjourn on this?
John, we have nothing else.
Okay.
And John, after that, may I be excused?
Yes.
Thank you.
Great to see you. Mr. Hawkins, good luck to you. All right, it's 10:32. We've been at this for about an hour and a half at this point. I'm going to take a 15-minute recess. Everybody step to the restroom, get back to your seats, don't be the person that wanders off. And we'll come back out at 10:50, take the next set of rules.
Yes, Judge.
Yes.
Could I have a press, please? Pretty tall, that's probably about right.
All right, Ms. Harper, raise your right hand. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down and say your full name for me.
Austin Elijah Harper.
Mr. Harper, you're here on 22 SR 0788. According to my calendar, you are on time for court, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Harper, your attorney's passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of the rights I read out earlier?
Yes, sir.
Are those your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And to ask your attorney any questions that you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Mr. Harper, have you had all the time that you need to speak with your attorneys about all aspects of your cases?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
All right, Mr. Harper, do you have any other questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
All right, Mr. Hudson, do you stipulate that there's a sufficient factual basis for me to accept this public indecency plea on 22 SR 788 from January 2nd of 2021?
We do, Your Honor.
All right, and Mr. Harper, do you wish to enter a guilty plea to this charge of public indecency?
Yes, sir.
All right, I'm gonna find between Mr. Hutchison's stipulations and factual basis combined with your request to enter a guilty plea that there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights in entering this plea. I've reviewed the recommendation that Mr. Hutchison has negotiated on your behalf with the solicitor's office, and I will follow the recommendation as it's been negotiated. Mr. Hutchison, the floor is yours.
Your Honor, just briefly, Austin doesn't have any kind of history. He realizes the error of his ways, and he will not tread this ground again, Your Honor. We did discuss first offender and the implications that it could have possibly beyond a day. Despite that, he was not interested in doing the first offender. And like I said, he's a young kid, made a really stupid mistake, Your Honor, and he's here owning it today.
And it looks like you've done some significant course correction already, because it looks like they started out as felonies, so.
Yes,
sir. Okay. All right. Mr. Harper, any questions about anything before we sentence?
No, sir.
You ready?
Yes, sir.
All right. Austin Harper, 22 SR 788 from January 2nd of 2021. Count 1, public indecency. I will find you guilty. It's 12 months probation, $1,005 is your fine. Count 2 is dismissed. You may work off your fine with community service work at a rate of $10 per month. $10 per hour. There will be show you valid license, no alcohol, illegal drugs, or hemp products. Should be tested for those. Fourth Amendment waiver, $25 intake fee, $50 per month supervision fee, 20 hours of community service work, no contact with Hannah Brownlee or looks like Henley Rhodes.
that's correct, Your Honor.
And that's the sentence of the court. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Do you remember me talking about habeas earlier?
Yes, sir.
You remember reading about it on the back of the right sheet, right there.
Yes, sir.
All right, any questions for me about anything before you and I part ways?
No, sir.
Mr. Hudson, anything else?
No, Your Honor.
All right, that concludes this matter. Thank you, Mr. Harper. All right, call your next client.
Go follow.
That way. This is Duncan.
Yes, Your Honor. Justin Keith Duncan.
All right, Mr. Duncan, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, and you can move that mic around and state your full name for me.
Justin Keith Duncan.
Mr. Duncan, you're here on 22 SR 448. Am I correct that you were on time for court today?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
And did you understand those rights?
Yes, sir.
I'm holding up this document, this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights I read out earlier?
Yes, sir.
And are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
And is this your signature?
Yes, sir.
Could you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And because you understood, I'm sorry, to ask your attorney any questions you have about it?
Yes, sir.
And because you understood everything that's on it?
Yes, sir.
Any questions I can answer for you about anything on this document?
No, sir.
Have you had all the time that you need to speak with your attorneys about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes, sir.
Okay. Do you have any questions for me about anything so far before I pivot to your attorney with my next set of questions?
No, sir.
All right, Mr. Hutchison asked to 22 SR 448 from October 19th of 2020. Do you stipulate that there's a sufficient factual basis for me to accept this reckless driving plea?
Yes, Your Honor.
You want to enter a guilty plea to that reckless driving charge?
Yes, sir.
And then count 2, following too closely. Mr. Hutchison, you stipulated that one as well?
Yes, Your Honor.
Mr. Duncan, you want to enter a guilty plea to that charge?
Yes, sir.
Okay, I'm going to find between Mr. Hutchison's stipulations and Mr. Duncan's request to enter guilty pleas that there's enough for me to take these pleas. I'm going to find that Mr. Duncan is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I reviewed the recommendation and I'll follow it. Anything you wish to add, Mr. Hutchison?
Your Honor, just that we asked you to accept the plea. There were several issues in this case that resulted in this recommendation, Your Honor. And I believe the trooper is all right with the recommendation.
Okay. Mr. Duncan, do you have any questions for me?
No, sir.
All right. You ready for me to sentence?
Yes, sir.
All right. Justin Duncan on 22 SR 448 from October 19th of 2020. Count 1, reckless driving, and find you guilty. It's 12 months probation, $1,232 is your fine. Count 2, following too closely, guilty, 12 months consecutive, 303 for a total of 24 months. You may work off all your fines with community service work. Count 3 is dismissed. Show your valid license to probation. No alcohol, illegal drugs, or hemp products. $50 per month supervision fee. $25 intake fee. 40 hours of community service work. Substance abuse evaluation within 90 days. And once 12 months have passed, no violations have occurred, and all conditions have been met, then your case will close. If 30 days from today, if you wish to appeal this decision, you have striving. You have 6 months from today if you wish to use your habeas rights. You remember me talking about habeas earlier?
Yes, sir.
Remember reading about it on the right sheet right there where I'm pointing?
Yes, sir.
All right, anything else that you have any questions for me?
No, sir.
Okay. All right, Mr. Hutchison, anything else?
No, Your Honor.
All right, I'm gonna pass you off to Mr. Taylor. Head up those double doors there and have, go meet with probation.
Thank you. Yes, sir. Thank you.
All right, what else do you have?
I believe I'm finished, Your Honor, if I can be excused.
Sounds good. Thank you.
Thank you, Judge.
Okay. Floor's yours. What do y'all need?
We ready on our cases, y'all.
Okay. Didn't y'all need to put something on the record, or y'all wanted to do
Yes.
this first?
We need, Patrick for
We
that.
can,
Okay, that's fine. I can work my way through your
actually, we can get back to that.
Okay.
It's venue was not proper on Mr. Britton. The incident
On which one?
on the first case on the calendar, Mr. Britton, Nicholas Britton.
There's a venue issue?
Yeah, there's a venue issue.
Okay. So,
So it's gonna dismiss it because the incident happened in Spalding County, but the property that we recovered in Henry County. So the case should have been put in Henry County, not in Spalding County, so it's dismissing it.
okay. All right, we'll cross that bridge. Okay, well, I mean, if they're gonna give me an alt cost, that's fine, I guess. If I need to have a,
I think he's gonna prepare one and bring it over.
okay, that sounds fine. Let me look through here, make certain these are all ready, and then we'll take please. I left the attorney defendant up there so that.
Yes, I have Mr. What is his name?
Item,
Adam
From yesterday.
from yesterday.
he's logged in, and Mr.
I talked to him, he said he ready.
And Mr. Brown, I'll talk to both of them.
Brown shoulder?
All right, let's come back to order. We're going to talk to the two virtual people. We're going to start with Mr. Brown. Mr. Brown, I'm about to send you an unmute request. If you'll approve that, please.
Yes, Your Honor.
Okay. All right, for record purposes, you're up on the screen. Your attorney's present in the courtroom, and I'm sitting on the bench. You are Joshua Brown.
Yes, sir.
All right, your case is 22 SR 0804. Mr. Brown, what's a good phone number in case we need to reach you?
618-225-1040.
All right, you gave me 618-225-1040?
Yes, sir.
Okay. So I called your name earlier, you didn't answer, but it was clear you were just trying to get logged in virtually, so I'm lifting the warrant, putting your case back to square one. So we're back to where we're supposed to be. Mr. Brown, your attorneys are here, and I believe they have an announcement on your behalf. Is that correct?
Ready for trial.
Okay. Mr. Brown, I understand that you do not wish to negotiate a plea and you wish to simply go to trial on your case?
Your Honor, I have a lot of questions that I'd like to be able to ask. But,
Okay. Well, I'm not going to go through those with you. That's between you and your attorney. I just need to know whether you want to talk with your attorney about potentially resolving the case or if you want me to move you towards trial. As far as your interactions with me, those are the only discussions I intend on having with you.
okay,
What do you want to do?
no disrespect, but I don't have, me and him have a language barrier. I don't really understand him fully. And maybe, so I would like to be able to speak to a different attorney.
Well, here's kind of the problem that I'm aware that Mr. Charles does not have a Southern accent. However, what I'll tell you is that Mr. Charles and Mr. Malloy are some of the most experienced defense attorneys in Georgia, and between the two of them, they have dozens and dozens and dozens, if not hundreds, of jury trials over the course of decades that I've watched them practice. So I know you have a little bit of a language barrier, but I would tell you to dig deep, listen well, because you are getting, frankly, the best public defenders in the state of Georgia. So, as far as just talking to somebody else, that's a no for me, because I'm aware of the high caliber of your the representation you're receiving. So, I know that's not the answer you wanted, but it is the answer you get, because I'm aware of how lucky I am as a judge every day when these two walk into the courtroom, as well as, of course, their amazing team. So, okay, so with that said, do you want to talk to them some more? You want me to set you down for trial?
I would love to be able to speak with him some more.
All right, here's the deal. You've given me the number of 618-225-1040. I'm going to let you remove yourself from the virtual system. They'll call you when they get to you. I'll be back on the bench tomorrow morning. If you're able to resolve your case, so here's the deal. If you talk to them and you just want to go to trial, you do not need to log back in and have another conversation with me. You will simply be here, physically present, in person, not virtual, in my courtroom on August 28th, and be prepared to stay for the week or until we resolve your case, whichever happens first. That's already on your reset notice. This is not new information. Do you understand that?
Yes, sir.
If you reach an agreement with your attorneys, you may log in tomorrow morning and enter your plea, or however your case gets resolved, and then we'll go from there. Okay?
Yes, sir.
All right. Do y'all need anything else from him before I cut him loose? All right. You're free to remove yourself from the system. You may move about. Just keep your phone on your hip, and when they call you, they're very busy this morning, so they probably won't get to you in the next little bit. But just keep your phone on you, and when it rings, answer it.
Yes, sir. Absolutely.
Thank you, Mr. Brown. You're free to release yourself. If not, I'll see you in person on the 28th here in this courtroom at 9 a.m. sharp.
Thank you. Have a blessed day.
Thank you. All right. Is it IDOM? IDOM? I'll just leave negotiations up and on around. Mr. Idom, I sent you an unmute request if you'll approve that. There we go. You there?
Yeah, I'm here.
Perfect. All right, so Mr. Item, I apologize for the confusion yesterday. I did not inform everybody that you had gotten logged back in. So you're here today, and it looks to me like y'all have worked out an agreement to resolve your cases. Is that correct?
Yes.
Is it acceptable to you that we're gonna handle these pleas over this video conference system?
Yeah.
Okay. Do you have the ability to turn your camera on? If you don't, we're okay, but I would prefer if we could.
I'm trying.
Again, if you can't, don't worry about it. If turning it on is gonna lock the system up because you don't have good Wi-Fi.
There he is.
There we go. I see you.
Okay.
All right, we're gonna try that. Is it Item or Item?
Item.
Item. All right, Mr. Item, will you raise your right hand there up on the screen? Do you solemnly swear or affirm the testimony you're about to give in these matters will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Perfect. Take your hand down and state your full name for me.
Jerry Item.
All right. Mr. Item, for the last several minutes, I have had up on the screen this attorney and defendant plea rights waiver. I'm putting it back up so you can see it. There we go. Do you recognize that document that's up on your screen?
Yes.
While it was up there, did you have an opportunity to read it from start to finish?
Yes.
If you were here in the courtroom standing in front of me and I were to hand this to you, would you be able to initial each of those lines on the left on each page, indicating that you've read them and that you understand them?
I don't know how to fill that out.
No, I'm not asking you to fill it out. I'm saying if you were here in the courtroom and I handed you this piece of paper, would you be comfortable initialing the line saying you understand it?
Yes, sir.
Okay, you're not about to fill it out. I'm gonna fill it out over this plea. And I'm gonna leave it up there. In fact, let me move this so we can see both of you. There we go. All right, so, Mr. Item, you have two cases, 22 SR 1578 and 1579.
3 cases, Your Honor.
Oh, there's 3?
Yes, 77, 78.
Oh, there's the null process. I see it. And then 1577 is gonna be dismissed.
Yes, sir.
Got it, okay, thank you, sorry about that. All right, so you have 2 cases we're gonna plead to, the third one's gonna get dismissed, do you understand that?
Okay.
All right, so follow me along with the document that's up on your screen, which is that, are you entering this plea knowingly, voluntarily, and intelligently? Or to put it another way, is anybody forcing you to take this plea?
No.
Okay. Do you understand, are you under the influence of alcohol or drugs?
No.
Do you understand the charges that you're about to enter a plea to, which is obstruction of a law enforcement officer?
Yes.
Do you understand that you have the right to a jury trial on these charges, including, you can see there, the right to be presumed innocent, force the state to prove your guilt beyond a reasonable doubt, cross-examine the state's witnesses, subpoena your own witnesses and evidence, testify or not testify, and the right not to incriminate yourself? Do you see that on the screen there?
Yes.
And you understand you're waiving those rights by entering these pleas?
Yes.
Is that what you want to do?
Yes.
Have you had all the time that you need to speak with your attorneys about all aspects of your cases?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
All right, you understand that you're going to receive probation
Yes.
and that you'll be required to abide by those terms or face a revocation hearing with me.
Yes.
All right, go to the top of page 2. Are you a United States citizen?
Yes.
All right, this is not a family violence case.
Actually, Your Honor, 77 would be dismissed. It's only going to be guilty to 78 and 79.
Oh, then I read the cases wrong.
Yeah, you read it, yeah. 77 is the family violence, that's going to be dismissed. He's going to be guilty to 78, to the obstruction on 79, and the obstruction on 78.
Okay, that what you just described is correct. I read it wrong out loud.
Correct.
And I apologize for the confusion that created. So, I read your case numbers out wrong a moment ago. Mr. Item, your attorney has corrected it, which is 1577 is going to be a dismissal when we're done. And that you're pleading to 2 counts of obstruction, 1 count on 1578 and 1 count on 1579. Is that correct, Mr. Charles?
Yes, sir.
All right, do you follow that, Mr. Item?
Yes.
All right. All right, so back to the rights waiver. Do you understand that by entering this plea, you're waiving your Fourth Amendment rights against searches and seizures?
Yeah.
And then that weird thing, habeas corpus, where you'll have 12 months from today to sue Spalding County if you wish to challenge these convictions.
Okay.
And then the last paragraph before the defendant line says that I reviewed this with you. Is that correct?
Yes.
All right, so obviously I didn't read it to you word for word. Any questions on anything that we've covered so far that I can answer for you about anything on this document?
No.
All right, so Mr. Charles, since he is virtual and has signed this, and you've signed here, you've reviewed these rights generally
Yes,
with
Your
him?
Honor, after you put it on, I call him and make sure that he didn't have any question about those.
Great. Okay, then we're good to go. Mr. Item, do you have, it is item, you told me that, correct?
Yes. Item.
Item, sorry, I have 1,700 things in my brain going on, and I forgot how to pronounce your name. Mr. Item, do you have any questions for me before I pivot to your attorney with my next set of questions? Okay. If you think of any, promise to ask me. Mr. Item, Mr. Charles, starting with 22 SR 1578 from May 4th of 2022, do you stipulate that there's a sufficient factual basis for me to accept this obstruction charge?
Yes, I do, Your Honor.
Mr. Item, do you wish to enter a guilty plea on 1578 from May 4th of 2022 for this obstruction charge?
Yes.
All right, moving on to 1579 from June 25th of 2022. Mr. Charles, do you stipulate the factual basis on this obstruction charge?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to this charge on 1579 from June 25th of 2022, Mr. Item? Do you wish to enter a plea on this, Mr. Item?
Yes.
Okay. Then I'm going to find between Mr. Charles's stipulations as to the factual basis combined with Mr. Item's request to enter guilty pleas on these two cases that there's enough for me to enter a plea. I'm going to find that Mr. Item is knowingly, voluntarily, and intelligently waiving his rights in entering these pleas. I have reviewed the recommendation, and I'm going to follow it as negotiated. Okay. Mr. Charles, anything you wish to add?
No, Your Honor, thank you very much.
Mr. Item, do you have any questions for me about anything before I sentence?
He said no.
No?
No.
Okay, then we're good to go. Mr. Item, starting with 22 SR 1578 from May 4th of 2022, as to count one, the obstruction, I'm going to find you guilty. It's 12 months probation, $590 is your fine. Count two is going to be dismissed. You may work off your fine with community service work, show your valid license to probation, no alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee. That's one $50 fee across both cases, but there is a $25 intake fee per case, so two $25 intake fees. You're also going to pay $50 to Spalding County to offset the cost of your attorney and 20 hours of community service work. That closes out 1578.
As far as community service,
I'm sorry?
I don't stay in Georgia, so how does the community service thing work?
Okay, hold on, your audio's breaking up a little bit. What I'm gonna do, Mr. Item, is I'm gonna shut your video off. We know it's you. That should fix our audio issues. There's just a gap there. All right, so where do you live?
I'm actually in Chicago. I stay in Chicago, Illinois.
All right, so I'm gonna put on here that you may go to phone report. It's actually e-reporting, since you're nowhere around here.
Okay.
Got it. Okay, so, and you can do community service work at any approved providers. Many of our providers are national nonprofits. And then if you have somebody local that you really want to use, you can apply to use that agency. But probation will have to review it and approve it first. So if you find a national nonprofit, that's your best bet.
Okay.
So, Goodwill, Salvation Army, anybody in that ballpark.
Okay.
Habitat for Humanity, there's tons of them. So, okay, does that answer the question?
Yeah.
All right,
Yeah.
I've marked on here that you're virtual. All right, moving on to 22 SR 1579 from June 25th of 2022. Obstruction, guilty, 12 months, 590 is your fine. Same conditions, you're gonna submit a copy of your driver's license, no alcohol, illegal drugs, or hemp products. Also, again, $150 supervision fee, but it is an additional $25 intake fee, an additional $50 to offset the cost of your attorney. And I've also marked that this is phone report. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Do you remember reading about habeas on the right sheet right there? We talked about it a moment ago. 2 lines above the signature. Excellent.
And sentences concurrent, Your Honor.
And the two sentences run together. Mr. Item, what's going to happen here next is I'm going to put on here that you are going to report to probation. I don't know when Director Matthews wants me to have you report.
I didn't have a phone number to give him, Your Honor.
Okay. How about this? You're going to need to reach out to probation. If you go to the Spalding County website and go to the Spalding County Sentence Enforcement page, you'll find all kinds of contact information and directions. And if you will please go to that website, you're going to need to send them an email. Their email addresses are all up there, and they will give you instructions. And I'm just going to simply put that you must check in with them within 3 days by e-report from today. And that just gives you 3 days to reach out to them virtually.
Okay.
Okay, fair enough?
Yep.
They didn't put the phone number on the probation sheet. It would be a good idea from now on, because he asked me for the phone number, I didn't have it to give to him.
Yeah, it's right. Yeah, their phone number is 770, I just don't have it memorized yet, 467-4206. Their phone number the whole department is new, and so I don't have everything memorized yet. But the phone number is 770-467-4206. So wait a day, let them get you into the system, and then give them a call.
Okay.
And again, you can go to spaldingcounty.com and you can go to their page. It's got all of it there.
Okay.
All right. Sorry for the confusion. Like I said, it's a new department. We're working it out.
Okay.
All right. Anything else?
No, Your Honor, I'm ready for the police.
All right. Mr. Item, you are free to remove yourself from the system. Just call that number tomorrow, okay?
All right. Thank you so much.
Thank you.
Miss Wagner, Your Honor. Motion. And Your Honor, she's requesting for offender.
Okay. Mr. Ragland, if you please raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down, state your full name for me.
Miyasha Natiri Ragland.
All right, and Ms. Ragland, my understanding is you were on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
I did.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No, sir.
Ms. Ragland, your attorney has passed up to me this attorney and defendant plea rights waiver. This is the written. Do you recognize this document as the written version of those rights I read out earlier?
Yes, sir, I do.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
And is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorneys any questions you had about it?
Yes.
And because you understood everything that's on it?
Yes.
Have you had all the time that you need to speak with your attorneys about all aspects of your cases?
Yes, I did.
Are you satisfied with the job they've done on your behalf?
I am.
Do you understand that you have the right to a jury trial on your case?
Yes.
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
Yes.
All right, so, do you have any questions for me about anything so far before I pivot to your attorney with my next set of questions?
No, sir.
All right, so, yes. All right, so, Mr. Charles, do you stipulate in 22 SR 1743 from December 29th of 2020 that there's a sufficient factual basis for me to accept this forgery plea of count 1?
Yes, sir, I do.
Do you wish to enter a guilty plea to that forgery charge?
Yes, sir.
All right, Mr. Charles, back to you. Count 2, is there a factual basis for the theft by deception?
Yes, I do, Your Honor.
And do you wish to enter a guilty plea to that charge, ma'am?
Yes, sir.
And then lastly, back to you, Mr. Charles, count 3, the forgery charge.
Yes,
Perfect.
Yes, I do, Your Honor.
And then, Mr. Ragland, do you wish to enter a guilty plea to that charge?
Yes, sir.
Have you used first offender on any other case anywhere else?
No, sir.
And are you wishing to use your first offender on this case?
Yes.
Ms. Ragland, you understand that by using your first offender today on August 15th on this case, you will never be allowed to use it again on any other case ever. Do you understand that if you do not successfully complete your terms and conditions of probation, and if I revoke your probation, you will both have used your first offender, lost your first offender, and been convicted of this charge? Do you understand that?
I do.
Is that a risk you are willing to take?
It is.
Okay. And you understand that if you don't do it, you won't get a jury trial, you just get a hearing with me, and then I make those decisions.
Yes, sir.
Perfect. I'm confident we will not have to cross that bridge, but it's my job to say awkward things like that out loud. All right, perfect. All right, I'm gonna find with Mr. I'm gonna find she qualifies for first offender. I'm gonna find that with Mr. Charles's stipulations combined with Ms. Ragland's request to enter pleas, there's enough for me to take the plea. I'm gonna find that she's knowingly, voluntarily, and intelligently waiving your rights. I reviewed the recommendation and I will follow it. Mr. Charles, anything you wish to add?
No, Your Honor, thank you very much.
Okay, so, all right, so let's talk through the restitution just a little bit before I jump in. It's a significant amount of restitution, and we've just started a brand new system this week on how we're doing restitution, so I want to make sure that.
I explained that to her at length, Your Honor, in my office.
Right.
That she only has 6 months, but she's planning on finish paying it off before the 6th.
Great, so you understand you'll take a one-time payment of $2,838.46 to the clerk's office within 6 months of today. Is that number a number that you can do? Can you bring that amount to the clerk's office within 6 months?
I asked you.
It's okay, I just need an honest answer so we can logistically plan. So I just need you to think about it hard. I need you to give me an honest answer of what you can do so that I can set up. I don't want to set you up to fail.
Yeah.
So what can you do, or what works for you?
I can do it.
Okay. All right, well then, if something happens and that's going to not work, you must communicate with probation.
Okay.
And one action I gave her, I told her if she can split it into 2 payments.
Well, that's what I was gonna do if she said she can't
split
do
it into 2 payments, take one as soon as possible and the next one. So that way, you're not in any financial bind to pay the 2,800, you can subdivide it into 14 and 14.
But you can certainly pay it earlier if you want.
It's your call.
Okay.
You want me to do that?
Yeah.
Okay, let's do that then. All right, so that means that, oh man, we're gonna do some math here, hold on. So that means that, you're going to make 2 payments in equal parts. So, so the way this will work is, so your total is 28, 38, 46. So that means that I'm gonna divide that by 2, which means that you'll take a one-time payment of 14, 19, 23, just divide it by 2, and you'll take that within the first 6 months. And then you'll have another 6 months to make the second payment. What I don't want and what I'm not allowing is for folks to take $5 a day over to the clerk's office and bury them in pennies. And so that's how this is gonna work. So I'm gonna put So I'm gonna put a note here that you're gonna do 14, 19, 23 in first 6 months and second 6 months.
And if I pay it before, it's fine.
Oh, yeah, of course. My job is if it gets pushed out, how are we gonna do this? And or have we communicated clearly about it? So, okay. And again, we're only a couple days into the system, so we needed a minute to kind of talk through, because we had specifically talked about this situation where 6 months was a tight time frame for such a substantial amount, so. Okay, does this work for you, Ms. Charles?
Yes, sir.
Does this work for you, Ms. Ragland?
Yes.
Okay, perfect. All right, so, then here we go. Miosha Ragland on 22 SR 1743 from December 29th of 2020. I'm granting your first offender request. So what that means is that as long as you successfully complete your probation without a revocation, then this will not go on as a conviction on your record. But you will not be allowed to use it in any other case ever in any other court. Do you understand that?
Yes, sir.
All right. Count 1, forgery, guilty, 12 months probation, $445 is your fine. Count 2, theft by deception, guilty, 12 months consecutive, $445 is your fine. Count 3, forgery, guilty, 12 months consecutive, $445. You can work off all of your fine with community service work at $10 per hour. But that is 36 total months of probation. Counts 4, 5, 6, I forgot how many charges you have. You have all the other charges will be dismissed. Yeah, okay. You are gonna show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those. You're gonna pay $50 per month supervision fee, a one-time $25 intake fee to probation, and you'll pay a one-time payment of $50 to Spalding County to offset the cost of your attorney. You will pay $2,838.46 in restitution. The way that will work is we're gonna divide that in half. You'll pay $1,419.23 within the first 6 months, and you'll pay it as a one-time payment to the clerk's office directly. You must take the receipt that you get from the clerk to probation. That's your proof of payment. If you do not take that receipt to probation, they will file a motion to revoke your probation. Do you understand that?
Yes, sir.
The second 6 months, you'll pay the second half, 14, 19, 23. Same rules apply. You'll take that receipt to probation. Failure to provide that receipt to probation as a one-time payment will result in a motion to revoke your probation. That will then be turned over to United Bank as restitution. You'll also complete 20 hours of community service work. Once 12 months have passed, no violations have occurred, and all conditions have been met, then you may go to non-report probation. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Okay, any questions for me before we part ways? All right, Mr. Charles, anything else?
No, sir. Thank you very much.
Perfect. If you will step out those double doors, ma'am, and go meet with probation. All right, you have next?
We have Bobby on it. Bobby.
All right, Mr. Kennedy?
Yes, sir.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for me.
Barb A. Kennedy.
All right, and Mr. Kennedy. Mr. Kennedy, you were here on time for court, is that correct?
Absolutely.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Mr. Kennedy, your attorney has passed up to me this attorney and defendant plea rights waiver, which is the written version of those rights. Do you recognize this document as such?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Absolutely.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job they've done on your behalf?
Absolutely.
Do you understand that you have the right to a jury trial on your case?
Yes, sir.
And by entering this plea, there will be no trial and this case will be closed. Is that what you want to do?
Yes, sir.
All right, do you have any other questions for me about anything so far before I pivot to your attorney?
No, sir.
All right, Mr. Charles, do you stipulate there's a sufficient factual basis on 22 SR 836 from July 16th of 2020 for count 2 stop sign violation?
Yes, I do, Your Honor.
You want to enter a plea to that charge? Guilty plea?
Yes, sir.
And then count 3, also a stop sign violation. Do you stipulate to that as well?
Yes, sir, I do.
Mr. Kennedy, do you want to enter a guilty plea to stop sign violation of count 3?
Yes, sir.
Okay. I'm going to find that Mr. Kennedy's, between Mr. Charles's stipulations and Mr. Kennedy's request to enter a guilty plea, there's enough for me to take a plea. I'm going to find that Mr. Kennedy has knowingly, voluntarily, and intelligently waived his rights. I reviewed the recommendation and I'll follow it. Mr. Charles, anything you wish to add before I sentence?
No, Your Honor, thank you. Oh, that's a 30 by 30.
Yes, I'm great with that. This is a good resolution. So, Mr. Kennedy, any questions before I sentence?
No, sir.
Okay, here we go. You said Barbe?
Yes, sir.
Kennedy, names are important. 22 SR 0836 from July 16th of 2020. Count 2, stop sign violation. Guilty, 12 months, 156.50 is your fine. Count 3, stop sign. Guilty, 12 months, 156.50. Now, I'm going to delay the start of your probation by 30 days. And if in the next 30 days you can pay off your fine in full plus a $30 program fee for participating in our 30 for 30 program, then that gives you 30 days, $30. You close that, there will be no probation. If you are unable to resolve your case by paying it off in full within 30 days, don't panic. What's going to happen after that is simply this. The probation conditions will kick in, and the conditions will be to show you valid license to probation. No alcohol, illegal drugs, or hemp products, and you'll be tested for those. A $25 intake fee, a $50 per month supervision fee, a $50 public defender restitution fee. Actually, the $50 restitution fee will apply either way. So your total to close your case is $156.50 times 2 plus the $50 public defender fee plus the $30 program fee. So $393 is exactly the number you need to close your case. Does that work for you?
Yes, sir.
Okay. I just realized that I was throwing numbers out there and I needed to give you a total. Okay, and then if you end up on probation, that will also terminate upon completion. So, all right, you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. You remember me talking about habeas earlier? About it right there on the right sheet. Okay, then that's it. If you will step back with Ms. Yarborough out those double doors and go to with probation. Thank you, Mr. Kennedy. Okay.
Mr. Wilkins.
Whatever Mr. Miller has your, those were mine.
See who I have left. I have, I think that was self-represented. Yeah, that's self-represented. Self-represented.
I don't know what he has left. I know he went in the back to call.
That's all right.
Y'all got Mr. Britton's case.
Yes, I will be on the record, so.
And then
lack of venue.
There's a venue issue?
Yes. He's gonna make some kind of motion.
Yeah, I filed a motion to dismiss.
Did you want to put anything on the record on that?
Yeah, Judge, so we looked into this. It's related to a burglary which occurred on Tomachichi Road in Spalding County. However, Mr. Britton is charged with theft by receiving. And the property that he was found with was stolen property. However, he was found with it in Henry County. So we'll be unable to, the theft, the burglary definitely occurred in Spalding County, but Mr. Britton is not charged with that. He's charged with the theft by receiving of some jewelry, an iPhone, there's a couple other pieces of property, but there is no way for us to prove venue in Spalding County as to the theft by receiving charge. The proper venue, that would be Henry County.
All right, that makes perfect sense. So this is a dismissal, and then I guess y'all will notify Henry County or whatever. I guess as far as my movement, it's just a dismissal.
Yes.
Whatever happens after that is whatever happens after that. Okay,
Will be Mr.
just want to make certain I have the procedure.
Mr. Shepherd can contact the DA.
Yeah, there's,
Okay.
it's a 2019 case.
Okay, yeah. All right, well, then I will sign that in all process when it's presented to me.
All right, I'll get it to you in just a moment.
Okay, then
Whatever Mr.
I
Lloyd have, I don't know what he has.
I have two that I'm not sure who represents. I think they're Mr. Singleton's Passion.
Yes, Your Honor.
That's yours. And then Richie.
Yes, Your Honor.
That's yours. Okay, that's all I have. I have a couple of null process. Let's do those.
All right.
That'll probably check a few of Mr. And then one of Mr. Singleton's, please.
And Judge, on Megan Williams, it's gonna be a reset on that, so she can.
Williams. Oh, Barry Williams.
Should be a Megan.
I'm on. Oh, that's from yesterday.
From yesterday.
Nope, I'll find it in a second. I'm looking at the wrong calendar. That's on the United. Yep.
What the announcement? What is he doing?
Okay. What are you done doing? Your Honor,
Yes.
I was able to reach out to Mr. Brown, and I answered his questions. I explained the situation to him. He understands the charges. He says he wants to go to trial, so I instructed him to be, I just reiterated what you already told him on video, that he should be here on the 28th, and I guess we'll see what happens then.
All right, well, thank you for that. And if he changes his mind, he's welcome to report virtually on the 24th. But
He told me that he wasn't going to come and you cannot make him come.
yeah, well, I can certainly, I may not be able to get him here from there, but I can certainly put him on the no-fly list and make his life pretty miserable. So
That's what he told me.
Mr. Brown says he's not
and I'm
coming, but that's
14.
another issue for another day.
Yeah.
So I read each charge to him. I gave him the state's recommendation that's on the table.
All right, that's fine. He'll come or he won't. He'll sort stuff out. The null process, because I think some of these are y'all's, I have Myers.
Yes.
That's
Dead
the
docket.
docket, yes.
Excuse me.
Yeah, that's a
ours.
medical issue, Judge. She's
Yeah.
It's a severe medical issue.
Okay, so Myers is a dead docket. Dewberry is a dismissal.
Calling me.
Do what?
Mr. One is good.
But don't answer it.
Dewberry's a dismissal. Got it. And then Owens.
That's two of those, yes, Judge. Those are ours, yes.
I just want to make sure y'all had all of your boxes checked before you guys. Okay.
No,
Do y'all have anything on this afternoon's calendar?
no, we don't have any
Okay,
interpretation.
that's fine. Just being careful. All right, Mr. Singleton, you're up. Do you have a preference of what order?
No, Your Honor.
Okay. Let's just do alphabetical then. I have Basham. That's yours?
Yes. That's one day. One day.
All right. It was on Monday's calendar, I think.
It was, Judge.
Your Honor.
Yeah, we did.
On Miss
Right.
Fleming, yes. Miss Fleming told her that she had to work in-person service from 1 to 5. She said, what's your schedule?
Yeah.
I work 1 to 9:30.
So can you make it earlier that day?
She said I can't come no earlier than Wednesday.
All right. Let's do this. Make a copy of that for me. And, because again, it's a new office. We're still working all the details out. Just make me a copy of that issue and then we'll sort it out. There might be a different day. Is there a different day?
She said they all did report.
Well, we're doing all the orientations together is what I'm remembering. So we'll figure it out. Do you work it's Thursday, right?
Monday through Friday.
Okay.
I mean, I didn't have a problem with recordings. I just asked, can I come in the morning? And she said no. He started at 1, so I'm like.
Okay, we'll figure it out. Like I said, I don't know what it'll be. It might be that my answer is that's when you need to come, but I will look at it and have a conversation. And whatever decision I make, it'll be intentional, and we'll see if we can work with you.
That's the one information on venue.
Oh, yes. Yeah, I'll just let me get that conversation started. So, okay, so my answer may be that is what you need to do, but I'll at least see if I can look at it.
Okay.
All right, let's come back on record on fashion. Raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, now for everybody tracking on calendars, Mr. Basham was on yesterday's calendar. Item number 2, Mr. Basham, you were on time for court today, is that correct?
Yes.
All right, and for record, we moved all of Mr. Singleton's cases today to try to make it easier on Mr. Singleton. Mr. Basham, did you hear all the rights I read out to the courtroom and see the PowerPoint I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No, sir.
Mr. Basham, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights I read out there?
Yes.
Are those your initials next to each of the lines on page 1?
Yes.
And page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it
Yes.
and to ask your attorney any questions you have about it?
Yes.
And because you understood everything that's on it?
Yes.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes.
Are you satisfied with the job they've done on your behalf?
Yes.
Do you understand that you have the right to a jury trial?
Yes.
And that by entering this plea, there will be no trial and your case will be closed?
Yes.
All right, Mr. Basham, do you have any other questions for me about anything before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Singleton, do you stipulate there's a sufficient factual basis for me to accept this plea of speeding?
There is, Your Honor.
52 to 35.
Correct, Your Honor.
All right. And that's from July 27th of 2020. Mr. Basham, you want to enter a guilty plea to that charge?
Yes.
All right. Then the sentence of the court, I'm going to find that with your admission of guilt combined with Mr. Singleton's stipulations and factual basis, there's enough for me to take the plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights to enter the plea. I reviewed the recommendation and I'll follow it. Anything you wish to add?
No, Your
Okay.
Honor. He's prepared to pay the fine today.
And Judge, if I could just chime in on that one.
Yeah.
That it was originally a DUI, however, the blood test came back is well under the legal limit. It was like a .03.
Okay.
So that's why the DUI charge was dismissed.
Okay. And I'll give you your total at the end of this so that you'll know exactly how much to go back there and pay probation. So they'll get that close. All right. Mr. Basham, the sentence of the court then is as follows. On 22 SR 0942 from July 27th of 2020 here in Spalding County, count 2, speeding, 52 to 35. I'm going to find you guilty. It's 12 months of probation. $303 is your fine. Count 1 is dismissed. You may work off your fine with community service work if you wish at a rate of $10 per hour. Do you have your valid license back?
I do not. They
Okay.
were held.
All right. All right, so we will need to get his license back.
You know, actually, I may have his license. I think somehow it
Well,
ended up in my.
Yeah, they end up with every now and then, because they used to.
They used to be
the
stapled to
way-
the top, right?
Frankly, you could hold it up to the light and see how many times folks have been arrested for DUI. Depending on how many staples were in the.
Top of your license.
Yeah, when I started practicing, that's how you'd hold it up and you'd go, I count 8 staples, that's 4 DUIs. But needless to say, they still end up with us every now and then. Okay, well, they can do that. But let me finish here. So, show your valid license, probation, no alcohol, illegal drugs, or hemp products, $50 per month supervision fee, and then a $25 intake fee. So 328 should close it. No, I'm sorry, 378. 378 will close it. I don't do math. This is why I don't do math. 378 will close your case and a valid license. That's it. You do those things, your case will close. You have 30 days from today. If you wish to appeal this decision, you have 6 months from today, because it's a driving case, if you wish to use your habeas rights. And hopefully Mr. Shepard has your license. If not, you can take a copy of this down there showing that count 1 was dismissed. You should be able to get your license back very quick. It's Tuesday, so they're open, so you should be able to get it back today, in my opinion, and show it to them and get your case.
Down to the DMV.
So, if you have to. So, hopefully Mr. Shepard has it. All right, that's it. You may sit back.
Thank you.
All right, Mr. Singleton, who else do you want to call?
Destiny Ritchie.
All right, we got that right here.
Ms. Ritchie.
All right, if you will please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down and state your full name for it.
Destiny Caitlin Ritchie.
All right, Mr. Ritchie, you are here on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir.
Did you understand those rights?
Yes, sir.
Any questions I can answer for you about those rights?
No, sir.
Ms. Ritchie, your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document as the written version of those rights?
Yes, sir.
Are those your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all of the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you have about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job your attorney's done on your behalf?
Absolutely.
You understand that you have the right to a jury trial,
Yes, sir.
and that by entering this plea, there will be no trial, this case will be closed. Is that what you want to do?
Yes, sir.
All right, any other questions for me before I pivot to your attorney with my next set of questions?
No, sir.
Mr. Singleton, do you stipulate as to the factual basis on 22 SR 811 from May 20th of 2021, to count 1 to shop, that there's a factual basis for the shoplifting plea?
Yes, Your Honor.
Do you wish to enter a guilty plea to that shoplifting charge?
Yes, sir.
And Mr. Singleton, back to you, do you stipulate to the facts on the possession of a drug-related object?
Yes, Your Honor.
You wish to enter a guilty plea to that charge, ma'am? Drug-related object?
Yes, sir.
Okay. I'm gonna find between Mr. Singleton's stipulations as to the factual basis and Ms. Ritchie's request to enter guilty pleas on counts 1 and 2, that there's enough for me to take the pleas. I'm gonna find that she's knowingly, voluntarily, and intelligently waiving her rights to enter the pleas. I reviewed the recommendation and I will follow it. Mr. Singleton, the floor is yours if you wish to add anything.
Yes, Your Honor, there's another ticket that's underneath there that was a driving with no license, and then there's the 812, which is, they're both going to be dismissed as part of entering into this plea. And Ms. Ritchie's been doing very, very well. Judge, her sponsor, was actually here this morning wanting to speak on her behalf. He's since left, but she's seems to be getting everything under control and her life back on track.
Yes, sir.
You did a really good job with your client here, Mr. Singleton. I got 2 dismissals to sign. So.
Thank you,
Okay.
Judge.
All right, Ms. Ritchie, you got any questions for me?
No, sir.
You ready for me to sentence?
Yes, sir.
All right, here we go. Destiny Ritchie on 22 SR 811 from May 20th of 2021. Count 1, shoplifting. I'm gonna find you guilty. It's 12 months probation, 590 you should fine. Count 2, possession of drug-related objects. Guilty, 12 months, $300 is your fine. You may work off your fine with community service work. Show your valid license to probation. No alcohol, illegal drugs, or hemp products should be tested for those with a 4th Amendment waiver. $50 per month supervision fee, a one-time payment of $25 as an intake fee, 20 hours of community service work, and once 3 months have passed, no violations have occurred and all conditions have been met, I'll allow your case to close. As to your other 2 cases, 19 TK 4840, that is, I believe, a null pros. Yep. All right, I've signed the null pros on 19 TK 4840, and then the other null pros is 22 SR 812. I've signed that null pros as well. Both are pursuant to plea negotiations. All right, Ms. Ritchie, any questions for me before you and I part ways?
No, sir.
Mr. Singleton, anything else?
No, Your Honor.
Okay, then I'm going to ask y'all from Mr. Richards here. He's gonna walk you out and go meet the
May I
probation.
approach, Your Honor? Williams.
Gary Grady Williams. Mr. Williams,
He is,
there's always one.
yeah, let's see, yeah, he's actually noticed to be here today.
Yeah.
As he's not appeared, we'll ask for a bond forfeiture and bench warrant in that case.
Yeah, because of the
It's
severity of those
stalking.
charges, you need to find your guy.
I believe he's wanted in Florida. Probably
Okay.
has something to do with it.
Well, with the charges as they are, if they make it through this county, they do not reset anyway, so amendment would find and we'll let you know.
Thanks,
And we're within Roger Anthony.
Okay.
We're ready.
All right, if y'all, and Mr. Singleton, I assume Mr. Shepherd knows what's going on with your other cases.
Only one more, and that was Roger Anthony, and we're still announcing ready at this point.
Okay, I'll leave negotiations open. Any motions, anything you're gonna worry about on that?
I don't think so, Judge.
That's fine.
And then there's, the last one of theirs that we do need to address is Megan Williams.
Yeah, that one, you just requesting a reset on that?
Yes, and it's not the first time that it's been continued, but I'm consenting to it on this one. Ms. Williams has applied for accountability court here. She is a resident of Bibb County. And Bibb County we've been in contact. She has done her intake assessments and all for Bibb County. They met last week at their team meeting like we do with ours here. And we just haven't got any word back from Bibb yet on the status of that.
And just for the record, if that doesn't happen, she's willing to move in with her father here, change her address here, so that we can be in this program. She doesn't want to have to relocate, but she will just to get into the program.
Okay. Well, we're very proud of our program. It's been,
Well, that's what I was telling her. I was like, I don't know anything about the Bibb County program. I like this one.
it's been wildly successful beyond my wildest dreams, and I'm very proud of it. So, okay, well, this sounds great. If she just, okay, so procedural question only, and we can go off record. All right, please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down and state your full name for me.
Harris Christopher Waterman.
Mr. Waterman, you're here on 22 SR 1814, and it is my understanding that, or my memory that you were on time for court this morning. Is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes, sir. I fully understand them.
All right, and do you also, I'm holding up the self-represented defendant plea rights waiver, which is the written version of those rights. Do you recognize this document here?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on here?
No, sir.
You have the right to have an attorney represent you. Do you understand that?
Yes, sir.
And you're here representing yourself?
I am.
Is that what you want to do?
Yes, sir.
And Mr. Waterman, you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
Okay. Mr. Waterman, you're charged with one count of reckless driving and that you did here in Spalding County on May 25th of 2021. Operate your motor vehicle with a reckless disregard for the safety of person and property. Did you do that?
Yes, sir.
Okay. Big pause. Do we need to discuss it at all, or do you want me to keep going?
We're good, yeah.
Okay. I'm gonna take you at your word that if you want to have a different discussion, you'd have it with me.
Yes, sir.
Okay? All right. Mr. Waterman, I'm gonna find with your admission of guilt, there's enough for me to take your plea. I'm gonna find that you're knowingly, voluntarily, and intelligently waiving your rights to enter this plea. I have reviewed the recommendation and I'll follow it. Any questions about anything before sentence?
I would like to ask the court's leeway on the probation. I am self-employed and I often work for small municipalities throughout the country. And I have to answer security questions to to enter their IT systems. And one of those questions is, have you been on probation and parole in the last 10 years? I am fully prepared to pay the fine today, now at this moment. And I would ask that you delay my probation for 24 hours and allow me to walk downstairs and make payment and full restitution.
I'm gonna move you over to the 30 for 30 program.
Thank you, sir.
So you're still gonna work through probation, but I'm delaying the start of your probation by 30 days. I'll walk you through it in just a second.
Yes, sir.
And that way you don't have to answer that question. Okay, anything else for our sentence?
No, sir.
All right, here we go. Mr. Waterman, 22 SR 1814 from May 25th of 2021. As you have the fine amount in full today and ready to close your case. Reckless driving guilty 12 months, $792.50. Pay that and $30, your case will close. Otherwise, you go on probation, then you will show your valid license, be tested for drugs, alcohol, and illegal substances. We'll have a $50 per month supervision fee and a $25 intake fee, and only then will your case close. But that's if you need it, which I'm assuming you won't. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. So $792.50 plus $30 to close your case.
Thank you, Your Honor.
All right, if you'll go back that way, thank you. Combs?
Judge, while Mr. Combs coming up, Mr. Combs coming up, Cynthia Gregg, the one that's in the wrong court
Yes.
today, she is a representative of the public defender's office.
Okay.
So she'll just need to come. Ms. Gregg?
Ms. Gregg, you're not in any trouble at all. You were at the you were at the wrong place at the right time.
Thank you, I appreciate it.
But I do need you to come back tomorrow morning because I've already released your attorneys for the day.
Okay, thank you.
So tomorrow morning, Wednesday, 9 a.m. sharp,
Thank you.
second floor.
Okay.
Okay, thank you. You're good to go. And go let them know that make sure to reach out to your attorney and let them know you're coming.
I will.
Okay.
Thank you so much.
Thank you. You're Ronald Combs? Yes. Mr. Combs, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. State your full name for me.
Ronald D. Combs.
All right. And Mr. Combs, you're here on 21 SR 2280. Am I correct that you are on time for court today?
Yes.
Did you hear the rights I read out to the courtroom and see the PowerPoint that I put up on the wall?
Yes.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights? Mr. Combs, you have passed up to me this self-represented defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes.
Do you recognize it as the written version of those rights I read out earlier?
Yes.
Are these your initials next to each of the lines on page 1?
Yes.
Page 2?
Yes.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
And because you understood everything that's on it?
Yes.
Any questions I can answer for you about anything on this document?
No.
And Mr. Combs, you have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes.
You have the right to a jury trial, and by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes.
You're charged with 1 count of DUI, and that you did here in Spalding County on 21 SR 2280 back from September 17th of 2020. Operate a moving vehicle while under the influence of alcohol to the extent it was less safe for you to drive. Did you do that?
Yes.
All right, I'm going to find with your admission of guilt that there's enough for me to take your plea. I'm going to find that you were knowingly, voluntarily, and intelligently waiving your rights. I reviewed the recommendation and I'll follow it. Do you have any questions for me about anything we covered before I sentence?
No.
You ready?
Yes.
All right, Ronald Combs, 21 SR 2280 from September 17th of 2020. Count 1, DUI. We'll find you guilty. It's 12 months probation, $1,683 as your fine. You may work off your fine with community service work. There will be 1 day to serve in the Spalding County Jail. I'm initialing time served on the jail time, so you will not have to go back to jail on that 1 day. Show your valid license to probation, no alcohol, illegal drugs, or hemp products. Fourth Amendment waiver, $50 per month supervision fee. There will be a $25 one-time intake fee, 40 hours of community service work, substance abuse evaluation within 90 days, and DUI school within 60 days. You have 30 days from today if you wish to appeal this decision, and you have 6 months from today if you wish to use those habeas rights. Do you remember me talking about habeas earlier?
Yes.
reading about it on the back of the right sheet, right there where I'm pointing. All right, can I answer any questions for you about anything before you and I part ways?
No.
All right, well, Mr. Combs, I'm gonna pass you off to Mr. Taylor. He's gonna walk you back, have you go meet with probation, and I'm gonna wish you the best of luck, okay?
Thanks.
All right, thank you. All right, Daniel. I should have Ms. Harris. That's you, ma'am? Okay. And what's your name, sir?
I'm Doug Thomas, the husband of Desmond.
Okay, that's fine. Just want to make certain I'll take everybody's seat here. Okay, then, Mr. McDaniel, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down and state your full name for me.
Cornelius McDaniel.
All right, and Mr. McDaniel, you were here on time for court today, is that correct?
Yes, sir.
Did you hear the rights I read out to the courtroom, and did you see the PowerPoint that I put up on the wall?
Yes, I did.
Did you understand those rights?
Yes.
Any questions I can answer for you about those rights?
No.
You have passed up to me the self-represented defendant plea rights waiver, which is the written version of those rights I read out earlier. Do you recognize this document as such?
Yes, sir.
Are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
Yes, sir.
Is this your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, I did.
And because you understood everything that's on it?
Yes.
Are there any questions I can answer for you about anything on this document?
No.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
You have the right to a jury trial, and by entering this plea, there will be no trial, and this case will be closed. Is that what you want to do?
Yes, sir.
All right. Mr. McDaniel, do you have any questions for me about anything before I pivot to the facts of your case?
No.
All right, then I'm going to start with count 1 DUI, and that you did here in Spalding County on 22 SR 1708 on June 2nd of 2022, operate a moving vehicle while under the influence of alcohol to the extent it was less safe for you to drive. Did you do that?
Yes.
Did you also, as to count 3, on the same day and the same course of events, operate your motor vehicle and fail to properly maintain your lane of travel?
Yes.
All right, I'm going to find with your admission of guilt as to counts 1 and 3 that there's enough for me to take your plea. I'm going to find that you were knowingly, voluntarily, and intelligently waiving your rights during this plea. I reviewed the recommendation and I will follow it. Any questions about anything before I sentence? Okay, you ready?
Well, I guess probation take care of that. I'm actually living in another county right now, so.
Where are you living?
We're in DeKalb County right now.
Okay, it's already on here.
Okay, all right.
So you've already done a good job on that part. That box is already checked.
Thank you.
So that's a good question. Anything else?
And I told him he could do his community service, alcohol and drug assessment, DUI school, and all in the cab as long as he clears it with probation first.
Absolutely. So, yeah, we're great with that. So,
Thank you.
okay. Cornelius McDaniel, 22 SR 1708 from June 2nd of 2022. Count 1 DUI. We'll find you guilty. It's 12 months probation. 1683 is your fine. Count 3, failure to maintain lane. Guilty. 12 months consecutive. 156.50 is your fine. That's a total of 24 months of probation, 1 day to serve in the Spalding County Jail, and initially time served on your jail time, so there's no additional jail time. Get your valid license back, show it probation. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $50 per month supervision fee, a one-time $25 intake fee will be added, 40 hours of community service work, substance abuse evaluation within 90 days, DUI school within 60 days. You may go to phone report after orientation, so you'll need to come back down here one more time to meet with your probation officer, do all the intake forms, and then you'll be on e-report. Once 12 months have passed, no violations have occurred, and all conditions have been met, then you will go to, then your case will close.
Thank you. You said you got DUI school in 60 days?
Yes. So if that's going to be an issue, communicate early and clearly to your probation officer.
That's fine. My license, is my license suspended?
So when you were arrested, did they take your license and suspend it from the time you were arrested?
No.
Okay, then the answer is, I don't have that information directly, but I can indirectly tell you that my license suspension from pleas like this are normally 120 days, but I don't issue it, it's by operation of Georgia law. But if there was a suspension previously as a result of this arrest, then my suspension folds back into that suspension. So that's why you're catching me hesitate just a little bit, is if there is a suspension and you're not aware of it, then my suspension will fold back into it.
I check my license regularly.
Yes.
I drive for FedEx, and I haven't had any indication that my license is suspended.
Is your license address correct?
I believe so, but I do call the DMV.
Do that, and there's an automated line as well.
I do that too. Yeah.
Great. So what's gonna happen is, as a result of this plea, there is a suspension that will go into effect. We will send it in within 48 hours, and then DDS will usually notify you within about a week. It'll be in your mailbox.
Okay.
So I'm saying, make certain that address is correct. And the moment you get it, take the actions they tell you to get your license back. But you should be able to get a permit to drive.
Exactly. Yeah.
So, but again, I'm taking some guesses here. DDS will make the final decision on that issue.
So I go back in the permit to drive.
So, yeah, I'm anticipating you being able to get a permit.
Yeah, like when I go back doing that.
Yeah, so I'm not saying why you shouldn't be able to.
So who would I get that from?
DDS.
Okay.
So, and they'll tell you in the letter they give you, this is what you need to do.
To get the permit.
Mhm.
Okay.
So, but we're anticipating you being able to get it. I just need you to clearly hear me say, I don't control that question.
So is that after 12 months or is that before?
No, as soon as you get the notice. So the moment you get that notice in your mailbox, you should be able to go get a permit.
Okay, all right, thanks.
I just want to make sure you know I don't control it. That's what I think is going to happen.
Okay, all right, thank you.
All right. If there's an issue that you think I can help with, you can go back to the clerk, ask for a hearing on a Thursday at a non-jury hearing day. And if there's something I can do, I will do.
Go back to his clerk.
If you need to come back and see me,
I got you.
we have a procedure for that. And if there is something I can do to help you, I will.
Okay, all right, thanks.
All right. Harris?
And then, so this ended up on my table. This
Truth, the whole truth, and nothing but truth, so help you God.
Yes, sir.
All right, state your full name for me.
Shanique Harris.
All right, Ms. Harris, you are here on, there it is, 23 SR 736. Your case is in warrant status. I called your name this morning and you weren't here. Where were you?
I'm sorry, Your Honor, I came 10 minutes late. I have to live here because my license situation.
Okay.
I ordered the lift, but apparently they just kept reordering drivers because he canceled.
I'm not tracking what you're trying to say to me, but I'm listening.
I tried to be here on time, but I came 10 minutes late.
Okay. All right, so what is it you're wanting to do with your case?
I came to see if I can get more time to hire an attorney. The date that I came in May, I originally came in May 4th because I was trying to get a permit for my license for work. That day is when they switched up everything since I couldn't get the permit and ended up saying, okay, since you're here, we're gonna do, I guess, the first appearance situation thing. So I guess I just got confused. I went down to the public defender's office to try to apply for the public defender. I explained my situation to them. They said that they sent me something in the mail saying that they needed more documentation. Later on, that was May 4th. The end of May, my house ended up getting shot up and me and my kids had to move. So that may have been why I didn't get the piece of mail that they said they mailed to me saying they need more documentation. So I had no idea that they needed more time, documentation, so they denied me. So when I called to see what was going on, they said to reapply, now they need more time. So I was trying to see, I just spoke with Ms. Porter. She said I might just need a whole reset in order for them to have more time. I can't afford an attorney because I'm in and out of work with this license situation. So I was just trying to beg for more time from you so I can try to get this situation resolved.
How do you spell your first name?
SHANIQUE.
Okay. I've also got someone very similar to your name that has an A at the end.
No, sir.
That's not you?
No, sir.
Okay, because that person has other active cases.
No, sir.
I don't have a birth date, so I can't tell. What's your middle name?
Monique.
There it is. Okay, I show that the only thing you had previously with me is a hands-free ticket. Have you had any other cases
No, sir.
pending with me?
No, sir. They dismissed that because that was my first one.
Okay.
The state's ready to go on this. Harris, she's had since May to obtain an attorney on this. I mean, we're on for trial.
I did, sir, and I can provide proof my house was shot up with my kids in it. I have to move as soon as possible. We wasn't safe there. I just moved to Rex, Georgia, and I can provide proof of that as well.
Well, here's what we're gonna do. It's a DUI, isn't it?
Yes, sir.
Okay. She's waived the right for motions. So I'm gonna split the difference, Mr. Shepherd. So I'm gonna allow the continuance, but I'm gonna say that this is the one-time continuance. They waived motions. So I'm not gonna have any pretrial motions on this. We're just gonna try it or not. And whatever date we pick is when we're gonna try your next case. Attorney or no attorney. Does that make sense?
Yes, Your Honor.
All right. Do you understand that you've waived the right to have any pretrial motions, that whatever needs to be heard will just be heard by the jury? Okay?
I don't really understand, but I don't want to hold you up.
That's all right. What I'm saying to you is that I told you what to do in May. I gave you the date. We've had some things that have come up. And that's what's got me agreeing to do the continuance. Mr. Shepherd is announced ready. You're on the trial calendar. I told you back then we were going to try your case. What I'm saying is, because of what you've got going on and the fact that you did have some communications with the Public Defender's Office, which shows some good faith, I am granting your continuance request.
Thank you so much.
But I'm also saying that I don't see any reason to allow all the motion things to hold on to. So if your attorneys have any motions to file, like as far as to suppress evidence or bring evidence in or anything like that, we'll just have to address that as we go.
Okay.
So we're just, because what happens is when we get to the next calendar, I don't want to stop and hear motions. I want to try your case.
Gotcha.
So that's what it's not punishment, it's just logistics, which is that I normally hear the motions, reset the case, and then that gives everybody a reset. And I'm not going to do that with your case. When we get to the next calendar, we're trying your case.
I understand.
And there's no moving it off the next one unless Mr. Shepherd asks for a continuance, and that would be his one-time continuance. You just got your one-time continuance. Does that make sense?
Thank you, Your Honor. Yes, sir.
All right, so motions are waived, reset is granted. We're trying this case one way or the other at whatever date Ms. Jordan's about to pick.
Okay, Mr. Jordan.
Mr. Shepherd, I understand your position on it, but hopefully this is a good middle ground for the two of us. So, all right, Ms. Harris, you may step over with Ms. Yarborough, step over to the light
Thank you,
switch
sir.
there, or wherever Ms. Yarborough directs you to go. Okay, this goes. All right, anything that needs to be put on the record? Got anything else?
Judge, on Andrew Baxter, we're just having a hard time tracking down that